The writ petition dismissed.
Item 60.
This is also dismissed.
Repeat the lordship. I put item number 6. Admit of justice service has been filed today. It is called for tender order. 8 lordship. But I beg to mention item number 14 of today's paper.
Yes.
But if we have sought for certain information from the time that we are yet to receive, so I pray for 3 weeks time in this case. I have taken consent from the other.
On the prayer for adjournment made by Mr.
P. Burga.
P. Parwala, counsel for the petitioner, which is not objected to by Mr. P. Pathak. This is the matter after
3 weeks.
3 weeks.
But if interim order passed,
Huh?
interim order passed.
Interim order passed, they can continue to do.
My lord, I'm praying for posting of an urgent matter.
Huh?
We are praying, my lord, I'm praying for a posting of an urgent writ petition. We have filed it yesterday.
You ask the registry.
My lord, today.
You ask the registry.
On Friday, my lord.
You ask the registry. Yes.
Yes, please, Your Lordship. In item number 1, my lord, we have filed our affidavit of the definitely called. Item
Huh?
number 1. Item number 1.
Item 1.
Yes.
Okay.
Please read. One of that matter will be listed by the long-term file by 30th.
30 years?
Yes, January.
30 years back.
Yes.
Writ petition. What?
30th of this January.
Huh?
So this will be listed.
No. Pending matter, you go and ask the registry, madam.
New matter.
Because of the
Not pending matter, new matter.
new matter.
New matter.
Okay, new matter. Yes.
It may be listed.
Yes.
Yeah. Let's read a lot. I beg to mention, item
To be listed when?
Friday.
Okay,
Yeah.
okay.
I beg to mention for item number 13.
Huh? Item?
Item number 13.
13 years.
13. Oh, sorry, 12.
Yes.
Lordship, I submitted
Okay, on the prayer for adjournment made by
MSP Bora.
Miss M.S.
P Bora.
P. Bora, Miss M.S.
Miss P Bora.
Miss P. Bora, learned counsel appearing on behalf of
My name is Kanan.
oh,
Yes,
wait,
what
appearing on behalf of the petitioner, yes,
Date made 6 months.
which is not objected to by the respondent. This is the matter after. This is the matter on give or take.
Month of March, my date made 6 months.
My lord, I forgot to mention, it's a new matter, my lord. We have
It's a new matter.
New matter.
Oh,
New matter, we have urgent. On Friday,
okay. Okay.
for district, my lord. Matter was listed on 13/5/2022, my lord. It's not in the field, my lord. On Friday, my lord,
No, not right.
or
Give or take.
any other day, my lord. Next week, my lord. 23. Lord, to mention an item for listing a motion stage, your lordship.
New matter.
I know your lordship, the notice has been issued, but it has not
Notice has been
listed.
issued. It cannot be motion anymore.
No, it is coming again for motion only, your lordship.
After issuing of notice,
The other side has not been present, your lordship.
what is the matter about?
It is against the order passed by Ombudsman RBI. Non-payment of refund of money, the lordship.
Refund. Give a date.
Very good. I beg to mention one unlisted. It's a pending matter last posted on 22/12/2023.
Give a date. Or you ask the, you go and ask to the registry. You go to ask the registry. Pending matter.
Any date, lordship.
Ah,
What date?
12 December, now February. You go and ask the registry first. Mr. Counsel, what's happening is because of this, we are giving dates for listing of cases. The cases that are already there in the registry, which are, where there is no mention made, they're getting stuck. Because all the matters that are being listed are fixed matters. So it's a problem. You go and ask the registry.
Lordship, in this matter, what happened that service has not been completed for a couple of months now. So want to take a fresh step again. So kindly list the matter so that we can take a fresh step.
You want to take fresh step.
Just fresh step here. Any
Okay.
day
Give next week. Next week.
we are Lordship, another matter where we want to study the previous authority has been transferred. So we file a I. So want to do
Authority meaning?
previous person who is a post has been transferred. The
So?
new person, new incumbent was there.
So?
So finally,
Contempt of what is this case?
it is pertaining to your lordship, public distribution. The contempt.
Contempt matter, contempt.
Any day, your lordship.
Okay.
25th,
Give a date.
26th or 21st.
May I please, Lord? My lord, I have supplied with some paper book, my lord.
Why paper book for what? We
Paper
should
book,
be,
my lord, relating to the.
we should have taken it straight away.
Yes, my lord.
No, no, what
My
is
lord,
your case?
My case is that, my lord,
You have been disqualified at the
my lord, disqualified for their wrong.
technical evaluation stage.
My lord, their wrong interpretation is that, my lord.
Where is the, any impugned order?
In order, lordship will see the last page, my lord. It is uploaded in the net, my lord. Page 115, my lord.
Yes,
Serial number 2, my lord. That is, they merely said it is a disqualified.
disqualified.
Yes,
So,
qualified.
so your grievance is that no reason has been given.
No reason, nothing, my lord, and I should not be also, because, my lord, internal, I have inquired why they have disqualified me. They said, my lord, because I do not fall MSCB category, because my turnover is 45 lakh. They said, my lord, but
No,
law
no.
says something
No,
else.
no, huh?
Law says something, my
Yes.
lord, lordship, kindly have a look.
Let us see the tender notice.
Yes, yes.
Page,
Lordship will see the tender, it starts from, my lord, 59, my lord.
Yes.
Operative part 61 and 69, lordship.
huh? Page,
Page, it starts from page 51. 59.
relevant page.
Relevant page is 61 and 69.
What does 61 say?
61 says, my lord, is a tender, my lord. MSCB is exempted, my lord. What is the bid document? We need-
Where does it say MSCB is exempt?
Yes, lordship, kindly have a look, page 61, my lord. That
Yes.
is the bid and date is there, my lord. Then below that, my lord, MSCB exemption for a years, my lord. Those who are heavy MSCB, my lord.
Where does it say MSCB exemption for a year?
Yes. Then I'm coming.
Where does it say the exemption? Acha, okay.
62,
Second
Page-
class.
page 62.
What is MSC?
MSC, my lord, micro, those who are
Micro small enterprises.
enterprise, those who are enlisted there, my lord, they no need to submit their earnest money.
No need to submit earnest
Yes, my
money.
lord. It is there, lordship will see at page 62 and 63, my lord.
Where does it say in 62? Where does it say that?
Lordship will see page 62, bottom, my lord, A.
Yes,
May I read, my lord?
yes.
EMET exemption, the bidder seeking EAD exemption must submit a valid supportive document for the relevant category as per so and so GMC with a bid. Then lordship will see next page, 63. It is very clear, my lord.
Yes,
If the bidder is a micro and small enterprise as per the latest guidelines MSME rule, the bidder shall be exempted from the requirement of bidder turnover criteria or experience certificate subject to the meeting of the quality and technical specification if so and so is offered, so and so. We are exempted. Then, my lord,
what is OEM? What is OEM? What is the meaning of OEM?
OEM, average. It must be some turnover, my lord. Earnest money.
No, you've got it.
OEM.
Okay. So basically your case is what? That you don't need to submit earnest money.
Yes, my lord. As per
So
the
according to you, you have been disqualified because you did not submit earnest money.
earnest money.
That's your case.
That is my.
And
Now,
what is
lordship,
your case?
now, lordship,
Ah.
once again, lordship will see, I have given the law, my lord. What is the limit, my lord? Like this, my lord, lordship will see, I have given. My lord. Yes,
Why don't you make it a part of your affidavit? First day itself you're giving
I submitted a
your-
paper book also, my lord.
your-
for the
your docu-
convenience
your-
of the court,
the documents you submit are thicker than your writ petition.
My lord. Lordship will see
Yes,
Lordship will see the second page, my.
second page, yes.
Yes, my lord. The micro enterprise where the investment plan, machinery, equipment does not exceed 1 crore and turnover does not exist 5 crore. Number two,
Where are
small,
you reading?
next page, my.
Next page means which page?
That
Next page from the
notification.
first page or the second page?
Second page.
Second page.
Number Roman two.
Roman two.
Yes,
Wow.
small enterprise where the investment plan,
Just a minute.
machinery.
Do you mean the third page, the side, this one?
No, my lord. This
Okay.
notification.
This one. This one, acha. So, why didn't you put this out part of your affidavit? You come with new things. We could have read all this beforehand.
Lord.
Yes, fair.
Second page, Roman
Yes.
two.
Yes.
The small enterprise where the investment plant and machinery equipment does not exceed 10 crore and turnover does not exceed 50 crore rupees. ₹50 crore.
So,
Lordship will see now paper book 226 page. Paper book which I have given my turnover.
page 226. Yes.
226.
Yes.
Turnover for 22-23.
Yes.
45 crore.
This is the financial year 22-23.
That I'm coming, my lord. Let me make one small summary. My lord, my assessment year will say my 22-23. 45 crore. Now lordship has seen when a person is a company is required to submit his income tax return. Income tax return we have to submit, my lord. Last date was 31st October 2023. That I have given, my lord, already downloaded from their website.
Where?
This type of paper, my
The
lord.
council, your basic case is on basis of documents which are not part of your writ petition.
My lord, no,
everything
my
is
lord,
lo-
that is the law point, my lord. That
No,
is
no.
the law point I am saying, my lord.
You,
Because they said,
these things could have been put in your writ petition. You put it. What is this? We are basically going to decide your writ petition
no, my lord.
on the basis of loose sheets of paper
No, my lord, not that.
on the
my lord.
first day.
This is the lordship is aware, my lord, when a person needs to submit their income tax.
No, I'm not on that. Why don't you submit
My
the
lord.
documents that you rely upon? They're not much also. Out of 2 pages. This is also another 3 pages. This is also another 3 pages. Why don't you make it a part of your writ petition? This is also again another 4 pages. Why don't you make it a part of your writ petition? Your writ petition, as it is so thick. You're not relying on any document here. You're relying everything which is not a part of your writ petition. And besides that, you have given another thing. This I can understand. But the other loose papers,
Newspaper I should have, my lord.
you find it. You find an additional affidavit.
My lord. Then fixing, my lord, on Friday, my lord, I'll.
I will not be there on 22nd.
Monday. Monday.
22nd also. 21 I will be.
My lord, till then, my lord.
What is your case?
Lordship, our case is not submitted the EMD
Ah.
from the record.
And
Lordship.
what about that
His certificate which he produced, it was taken the printout in the month of January 2023 and NIT was floated in the month of October.
okay.
So if it was taken up hereafter, Lordship, it will come automatically come medium because the financial year we take
Financial year. Okay. That is from April to March.
April to March.
So his
NIT
And
says.
one
income tax return.
Lordship.
What income tax return or what document is it like?
The MSME certificate, Lordship, which they produced and claiming to be a small.
MSED,
MSME.
MSME,
ME.
MSME certificate which he produces.
Lordship.
It shows
Their
that
Lordship, they have taken a printout on 24/1/2023.
24/1/23.
23, where he shows as a small. But if it taken after the March, then it will come automatically come negative.
So we have got to we have got to see his turnover
Gotcha.
for the period from 1st April
Gotcha.
22 to 31/3/23.
Yes.
You bring that.
My lord, that is wrong submission, my lord. Lordship will see page 69 of my report. They are asking, my lord, page 69 be seen, my lord.
You see,
What
Mr.
they are-
Counsel, I'll tell you one thing.
Lord,
Usually I try to read a little bit before coming. Your writ petition is basically on the basis of papers which are not in the writ petition. You file your writ, you file all these documents. No, I don't do this kind of work. Right. As the petitioner has made submissions on the basis of loose sheets of paper,
that
which
cannot
have
be
not been made a part of the writ petition, the petitioner is granted time to file additional affidavit incorporating all the loose sheets of paper that he has produced today. List the matter on
22nd.
my lord, till then, my lord, they shall
22nd.
not do any.
No, Lord.
Otherwise you file it, you file.
I'll file it, my lord, let them not to finalize, my lord. Otherwise, my petition will be in fact.
Mr. Counsel, you have got to be fair, not only to the court, but to your colleague. You cannot make a petition and then rely upon loose documents on your first day. If you are going to rely on I can understand if the
This is
loose
the
sheets
law,
came.
my lord. This is the law related.
No, Mr. Counsel, what, the law,
This
you
is
put
the law,
everything.
my lord. Hope, my lord.
Please, you should at least put your pleading so that we know where you're going. Right.
My lord, till then, my lord, they shall not do anything.
Friday.
Lordship,
Why?
I am going out of station from 15, Lordship.
Two?
Let it be on 20, Lordship. 20. Tuesday or 21.
19?
19, I will not be.
Why? What?
Lordship, Raman is going to Ram.
My lord, till then, my lord,
Your friend will be there. Some other CGC will be there. You don't have to be.
On 20, Lordship. 20, I will be.
but they shall not do anything, my lord. Only that much.
No, you've got to be fair. This is not the way to do it. Ah, yes.
Uh,
Yes,
affidavit of, morning I went for
yes. So is there any objection to the,
Not of that. Yeah, Ballard, here we have appointed the arbitrator in earlier, but he has, that arbitrator has, he withdrawn his standard for as a arbitrator. But in
you cannot withdraw, you cannot appoint,
Yes, sir.
so he has withdrawn.
Withdrawn, right. That
So-
is the present status.
So that's the present status.
Yes, sir.
So you also don't mind that it should go for arbitration. Only thing is that in terms of the arbitration clause,
Yes, my lord.
the arbitrator should be appointed by you.
Yes, my lord.
Where is that page?
Affidavit, I think. Copy.
Give me a copy.
Yes.
Yes.
Yes, from page number 147, my lord.
One,
147, para 5, my lord.
para five.
Yes, sir. Petitioner demanded for appointment of arbitrator in terms of CPC fact letter and which was received by respondent number. The railway has asked the consent for the petitioner for waiver of applicability of section 12(5) of the Arbitrator and Constitution Act 2015, fact letter dated so. In reply to that letter, petitioner has not agreed to waive of the applicability of 12(5), my lord. That is the dispute, my lord. After that, my lord, next para 6, my lord. Respondent asked the petitioner to suggest at least 2 names from the list of nominal panel of 4 retirement railway officers who are empaneled for the arbitrary in NF railway fact letter dated so and so, and also sent a reminder letter so and so. The petitioner did not agree for appointment of arbiter from the panel railway officer, railway retired officer, and contained his disagreement. After that, my lord, they said that as per contract agreement, the contract are.
Where is the contract agreement?
Yes, my lord.
Where is that page?
That is, yes, my lord.
Where is the arbitration
Withdrawal, my lord.
clause?
Arbitration clause, my lord,
Page 129.
of the,
Claim
petition-
petition.
of the arbitration petition.
Yes,
That is, my lord, clause 64, my lord, demand for arbitration, my lord. That appointment of arbitrator, my lord,
just a minute, 129, demand for. Okay, 64.3.
64.3, yes, my lord.
Now, what is the dispute amount?
That is, my lord, waiver of 12.5.
Huh?
My lord,
The
my lord,
amount,
a dispute, my lord. Dispute
amount of dispute, how much?
amount of one,
Total 26,91,000.
Then come to 643, 664.3.
Right.
One is 10 lakh, single arbitrator.
So if
Beyond 10 lakhs is,
it is by railway, then it will be the arbitrator.
Yes.
But your tip can appoint one arbitrator, sole arbitrator.
okay, so sole arbitrator.
yes, my
There
lord,
is no
yes,
bar.
but, last occasion, honorable court, directed to take arbitrator, take instruction whether the arbitrator or.
Yes, yes, yes. So what is,
That is the point that we got. As per their instruction, my lord, my instruction is to for three arbitrators, as per contract agreement. 64.39.
64 point?
3, my lord. That is same, just now we have in my lord.
No, I have not said that. It's easier as per Guwahati High Court order on, mentioned that 3 arbitrators can be appointed only.
Yes, my lord.
Only 3 arbitrators can be appointed.
But as per contract agreement, right, that is
As
up
per
to your,
contract.
up to your lordship, you know, but as per contract agreement. Okay, there is a-
Yes, as per,
That is as per contract. Clause number 64.3.
then you'll have to follow that.
64.3 is not applicable.
You follow, only
64.3
problem
is
is,
not
only
applicable.
problem is it will be very costly and have it here. So you both agree that single arbitrator. That is the fact.
From my side, that is your, up to your lordship, but my instruction is that should be the three arbitrators.
Actually, he cannot say, he cannot say before the court, but the actually not think by appoint. Matlab, because 63, 64.3, that is not applicable. Like in view of 12.55. In view of section 12.5, that is not applicable. Because what does it say? It is federal chief gazetted railway officer, not below JA and out of the 2 serving officer, 1 retired officer. 2 serving officers not cannot be allowed. So this clause is not applicable at all. In that view, and they have not appointed some arbitrator. So in that view, the matter is before the court. Now court can appoint sole arbitrator, so there is no court. So this clause is not applicable. So the sole arbiter can be appointed. Yes.
How do you say it's not applicable? How can you say it's not applicable? When the number of the arbitrators has been specifically mentioned in the contract agreement and you have signed it,
Right.
how can you say it's not applicable?
Right. That
It is only with regard to,
if they are
it is only with regard to whether the railways can appoint their own arbitrators. That issue has been decided by the Supreme Court. Now, this issue with regard to 6.4, 364.3, A1 and A2, this is a different issue.
That is regard that says that two arbiter, two railway gazetted officer, not below railway gazetted officer. Two gazetted
That part will
That is
go,
one part.
the,
Now the only question is whether in spite of this clause, whether the honorable court can appoint for arbiter. That is. main issue.
correct.
I think
You
that
please give your arguments on
is
that.
the main issue.
Give the arguments on that.
If they are not agreeing to it, then pilot, I found one decision earlier.
Okay, right. You bring the decision.
Wednesday.
You bring the decision.
Yes, that is.
On the prayer, the parties list the matter after. To it.
On Wednesday,
Next.
Master.
then you want decision.
Next. Yes,
My lord, can a date be fixed?
yes.
Otherwise, Wednesday will not come.
After 2 weeks, give it. After 2 weeks.
Yeah.
Yes.
But in our case, well, as per arbitral clause, well, place of arbitration is mentioned at well, Mumbai.
Mumbai.
Yes, well, and in
Then,
lordship pursuant to that clause, my landed friend is well, arguing that well, jurisdictional court is well, Mumbai High Court to appoint
Ah.
arbitrator.
So, ma'am, your lordship has already dictated the order.
have you stated?
Yes, yes.
What order?
My argument was since the
Where have I dictated?
your lordship had dictated the order, only he was supposed to bring if there is any judgment to show the contrary. I have relied on the same.
Oh, in item 50 of 2023, just ask them, have I passed the order?
My argument is lordship, not that jurisdiction. There is no question of separate jurisdiction like
8 to 7. Huh? You got it? Print out. This bit? No, no, that is just the notes I made.
it was almost
Where is that? Just get it.
my argument. Your lordship was that not the jurisdiction, because the jurisdiction as defined in CPC is different from the jurisdiction as defined in the CPC.
No, I think they are various judgments of the Supreme Court.
And seat.
Huh?
Well, there was a well,
The issue with regard to venue and seat.
yes, well.
Ah.
We are arguing that venue and seat cannot be well, interchangeable. Venue is-
Interchangeable.
Lordship, venue is well, convenient venue. It's a
No, but then there was the judgment of the Supreme Court where it was said that when the Madras High Court had appointed an arbitrator, while the arbitration clause had said that the venue would be Bhubaneswar,
lordship.
then
yes.
the Madras High Court could not have appointed a
Lordship.
arbitrator.
Now,
So that is the case you are relying upon.
yes,
So as per that judgment,
yes, yes.
which appears to fit in with the facts of this case,
Yep.
outer the venue is where? Mumbai.
Mumbai, yes.
The venue is Mumbai.
Oh.
So why won't that judgment be applicable?
No, well, that was well decided on 25 of July 2020.
25 July
So,
2020.
25 July 2019, my lord. Sorry, my lord.
2019.
19. And we are relying upon a judgment that is well decided on 24/3/2022.
24/3/2022.
2022. Lordship.
Two judges again. Two judges.
Two judges judgment. They are also relying upon two judges.
No. In my.
Well, our case is, Lordship, there is a lease agreement which is executed within the territory of district of Dorong, Assam, and operating in Assam, and my learned friend is representing office of the company from Guwahati, not from Mumbai. He is representing Guwahati office. So,
Maybe representing any place.
that matter is coming in this case. That's why I have
Okay,
represented it. So, here, which one we are relying upon here? These facts also that there is a development agreement which was executed in the within the territory state of Bihar, and in the clause, the sitting was mentioned at the Kolkata. Accordingly, respondent was filed an arbitration petition under section 11 before the
So sitting and venue, what is the difference?
there is a convenient in terms
The seat and venue, what is the difference?
venue is a convenient place in terms of the section,
The venue, what if they say the venue of the arbitration would be at, supposing it says in Madras, or if they say venue arbitration is at Goa, does it mean that the seat of arbitration would be at Goa?
That is well, part is autonomous. They can sitting in Kolkata, they may sitting, yes, sir.
Mr. Counsel, when the arbitration clause specifically provides
Yes, not
that the venue would be at a certain place, can you have the venue at some other place?
we are coming on that. Lordship may kindly have a look on
Now,
that.
let us see your arbitration clause here,
Yes, sir. Page spell 36 of petition.
page 36.
Yes, sir.
Yes,
Page 33 the close, close 22.
page 36, clause
22. My
para 22. Okay. Yes,
Any dispute or claim between the parties hereto arising out of or relating to this agreement or its implementation and or its effect or the breach termination due to efflux of time or otherwise or invalidity thereof either during its subsistence or after its termination shall be referred to the arbitration of a sole arbitrator in accordance with the provisions of Arbitration and Reconciliation Act 1996. The arbitration shall be held at Mumbai. Look, this is well
but now what does it, what do you understand by the word, the arbitration shall be held at Mumbai? Does it mean that the venue of arbitration shall be at Mumbai?
Mumbai, look. Yes, not seat.
Huh?
That is not seat.
Now, what is the difference between venue and seat? That's what I'm
Yes,
asking you.
yes, no, we are coming to this. Yes.
Please, take me directly to that.
Page 45, Lord.
Page
Oh, sorry, paragraph 45 of our judgment.
Okay. Paragraph 45.
45. Page 9 of the judgment.
Paragraph 45.
Bottom, Lordship, bottom.
Yes.
In Mankastu Impacts Private Limited versus Air Visual Limited, so reported in 2025 at 399. At least the branch of which one of us, Honorable as Bhupana Justice, was a member, held below. The seat of arbitration is a vital aspect of any arbitration proceeding. Significance of the seat of arbitration is that it determines the applicable law when deciding the arbitration proceedings and arbitration procedure as well as judicial review about the arbitration award. The citus is not just about where an institution is based or where the hearings will be held, but it is all about which court would have the supervisory power of the arbitration proceeding. In so and so, the Supreme Court held that the location of the seat will determine the courts that will have exclusive jurisdiction to oversee the arbitration proceedings. It was further held that the seat normally carries with it the choice of that country's arbitration material law. 20. It is well settled that seat of arbitration and venue of arbitration cannot be used interchangeably. It has also been established that mere expression place of arbitration cannot be the basis to determine the intention of the parties that they have intended that place is the seat of arbitration. The intention of the parties as to the seat should be determined from other clauses in the agreement and the contract of the parties. So venue and seat are different. When it's just a convenient place, in terms of the section 20 of the Arbitration Act, it is a party's autonomy, Lordship. It may be Kolkata, maybe Mumbai, maybe Guwahati, Lordship. First, in terms of the section 20 of the Arbitration Act. Now, kindly,
Well, let us see section 20 of the arbitration.
Lord.
Just a minute, in this page.
Yes, Lord. Kindly have a
Just a
look.
minute. Brahmani River Pallet. While deciding this case,
Well,
uh, it did not consider this Brahmani River Pellets Limited case, is it?
there is no conflicting with,
There is no conflict.
yes, sir. There is, and moreover, in that, in my planet
Then-
line,
And then you come here, then you come to, then matter with council. If you say that there's no conflict,
But-
you come to that Brahmani River Pellets Limited,
not
Para 19.
there are no, yes, sir. When the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras High Court erred in assuming this regime under section 12. But so here is well different about well facts also. This well agreement was executed in Bhubaneswar, made in Bhubaneswar. Kindly have a look in paragraph 3, sorry, 2 well.
Paragraph 2.
Brahmani, yes, well. Brahmani. Paragraph 2. The three facts which lead to filing of this appeal are as under. The appellant entered into an agreement with the respondent for sale of 40,000 WME of iron or pullets or FOB terms and payment was to be made by letter of credit in Bhubaneswar. Made by letter of credit in Bhubaneswar. You know, place of execution at the Bhubaneswar. That is right.
And the destination was Chennai.
Well, Honorable Court is very,
Destination was Chennai.
yes, well, Honorable Court is very much aware. Every well case.
Let us see the arbitration clause here. Para 4.
Therefore, yes.
Arbitration shall be under the 1996 Act,
Venue of
and the venue of arbitration shall be at Bhubaneswar.
Bhubaneswar, yes, sir.
Now, here in your case,
Lordship.
what does the arbitration clause say?
Yes, sir. Paragraph 3.
What does it say?
The applicant and the respondent entered into a development agreement dated 15 June 2015 for development of property situated at Muzaffarpur.
No, where is the arbitration clause? Which page?
Page, well, page 3, my lord. Paragraph 3. Paragraph 3.
Page 3, paragraph 3 of which? Of the of the arbitration petition?
No, my lord. Judgment from judgment.
I am saying in your case between you two, where is the arbitration clause?
Lordship, page 36. Page 36. Your lordship, if I may say, this issue has been even subsequently settled by a three-bench judge of the Supreme Court.
In that
Your lordship, what is it? He is trying to connect that if a arbitration, if a place or seat, whatever name we call it, if we select the place which does not have a cause of action, then it not be given effect to, which is totally against the autonomy principle that is given in the arbitration, because parties are free to
Select their
select
seat.
a place and a seat, whatever name we call it, and that is the cruel law, meaning thereby the courts in that jurisdiction will have supervisory power over the arbitration, meaning thereby section 9, section 11,
appeal
34,
34,
37.
37.
Yes, my lord. So now, otherwise in international arbitration, the law also comes into effect. Here the law is definitely uniform. However, the seat is only for the connecting which court would have.
Which court will have jurisdiction over
Right.
that arbitration
Yes.
proceeding?
This judgment was considered in a
No,
three-bench.
just a minute. Page 36 is there.
Yes.
Okay.
Let me
No,
complete,
no.
my lord.
So what is he trying to say now?
He's trying to say the seat, venue and the seat are different. That is, he's trying to say 23, which gives the arbitrator to select the place of hearing.
Oh,
Place
that is
of-
a different
that is a
issue.
different-
That is a different issue.
I'm on 21, where the
23 is after he's been appointed
Yes.
with the parties, they can have it anywhere.
anywhere. Yeah,
Only thing is that they will be bound
but that
by the
seat-
courts of that seat.
yes,
That is, they'll be bound by the Bombay High Court or Goa High Court or whatever.
Yes.
I mean, Goa is Bombay, but Delhi High Court or whatever.
or nothing. And I'm on 21, and my contention is that our arbitration clause is 21. Though it says place, it says the place shall be. Even this word shall has been considered by the three bench. And this, your lordship, the judgment I placed, Brahmami River Pallet, was considered by the three benches and said to be correct. And later on,
Where does it say?
BGS, your lordship, we will coming on that. Well, BGS is, let me complete my case. My lordship will, let me complete first. We know the BGS well. We
No, actually, I asked him, that's why.
sorry.
Mm.
Well, our case is that, lordship, arbitration clause is here that we arbitration shall be held at Mumbai. Similarity is there in our judgment, which we are relying upon. Kindly have a look at paragraph 3, my lord.
Paragraph 3.
Yes,
Yes.
my lord. Facts are similar facts.
Yes.
The applicant and the respondent entered into a development agreement dated 15 June 2015 for development of property.
Just a minute. This is that Ravi Ranjan developers.
Yes, Lord. Aditya
Tara?
Para 3, Lord.
Tara 3. Okay, that's when he's a precedent for issue of law.
Yes.
How does it read?
My lord, paragraph 3 we are reading.
Please read. How does it start?
Lord. The applicant and the respondent entered into a development agreement dated 15 June
Okay.
2015
Okay.
for development of property situated at Muzaffarpur in Bihar, measuring about 12 kathas and 11 routes for only described as a development agreement outside the jurisdiction of Kolkata High Court. The said development agreement executed and registered in Muzaffarpur in Bihar contains an arbitration clause which is set out here in below for convenience. But this is the clause that in case of any dispute or difference between the parties arising out of and relating to this development agreement, the same shall be settled by reference of the dispute or differences to the arbitrators appointed by both the parties. Such arbitration shall be conducted under the provisions of the Indian Arbitration Conciliation Act 1996 as amended from time to time, and the sitting of the said arbitral tribunal shall be at Kolkata. Our facts is that our agreement is executed in Assam. Well, a place shall be at Mumbai. It is mentioned in our clause. Now, well, let's see
Now what?
paragraph 19, well,
Paragraph 19.
19. Sorry.
Yes.
In Kiran Singh and others versus Kaman Pawan and others, 1955, SCR 117, AR 1964, SC 340. A four-judge bench of this court held that it is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even collateral proceeding. A defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of the subject matter of the action, strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of the party. Now, I will paragraph 21. The question in this case is whether the Kolkata High Court had territorial jurisdiction to pass the impugned order. The answer to the question has to be in the negative for the reason that the development agreement was admittedly executed and registered outside the jurisdiction of the High Court of Kolkata. The agreement pertains to development of property located in Muzaffarpur outside jurisdiction of the Kolkata High Court. The applicant has its registered office in Patna outside the jurisdiction of Kolkata High Court. The applicant has no establishment and does not carry on any business within the jurisdiction of the Kolkata High Court. As admitted by the respondent, no part of the cause of action had arisen within the jurisdiction of Kolkata High Court. Now, my lord, paragraph 20 may be 25 may be paragraph 25.
Yes.
In the present case, no suit could have been filed in any court over which the Kolkata High Court exercised jurisdiction. Since as stated above, the suit admittedly pertains to the property situated at Muzaffarpur in Bihar, outside the territorial jurisdiction of the Kolkata High Court, and admittedly, no part of cause of the action had arisen within the territorial jurisdiction of the Kolkata High Court. The applicant who would be in the position of defendant in a suit neither resides nor carries on any business within the jurisdiction of the Kolkata High Court. Paragraph 27. At the same time, an application under section 11.6 of the Arbitration and Conciliation Act for appointment of an arbitrator, arbitral panel cannot be moved in any high court in India, irrespective of its territorial jurisdiction. Section 11.6 of the Arbitration Conciliation Act has to be permanently read with section 2(1)(e) of the Act and constitute to mean a high court which exercises superintendent supervisory jurisdiction over a court within the meaning of section 2-1 of the arbitration constitution act. Now let's kindly have a look at 46, paragraph 40. Paragraph 46.
Yes.
In this case, the development agreement provided that the sittings of the arbitral tribunal would be suspended in Kolkata. As observed above, the parties never agreed to submit to the jurisdiction of Kolkata High Court in respect of dispute. Nor did the parties agree upon Kolkata as the seat of arbitration. Kolkata was only the venue for sittings of the arbitral tribunal. Now, 48. Look. In this case, the parties as observed above did not agree to refer their disputes to the jurisdiction of the court in Kolkata. It was not the intention of the parties that Kolkata
Wait, where did it?
No.
Which para?
48.
48.
Yes.
Just a minute before that. Yes, next, yes, 48.
Okay. In this case, the parties as observed above did not agree to refer their disputes to the jurisdiction of the courts in Kolkata. It was not the intention of the parties that Kolkata should be seat of arbitration. Kolkata was only intended to be the venue for arbitration sitting. Accordingly, the respondent himself crossed the district court at Muzaffarpur and not a court in Kolkata for interim protection under Section 9 of the Arbitration and Reconciliation Act. The respondent having himself invoked the jurisdiction of the district court at Muzaffarpur, he stopped from contending that the parties had agreed to confer exclusive jurisdiction to the Kolkata High Court to the exclusion of the other court. Neither of the parties the agreement concealed. The arbitration clause to designate Kolkata as the seat our interest. We are constrained to hold that Kolkata High Court inherently lacks jurisdiction to entertain the application of the respondent under Section 11(6) of the Arbitration Act. The High Court should have decided the objection raised by the appellant in the jurisdiction of the Kolkata High Court to entertain the application under Section 11(6) of the Arbitration and Reconciliation Act before appointing an arbitrator. These appeals are therefore allowed, and the Queen orders the appointment of arbitrator and the individual of the review application set aside. Well, pursuant to the death arbitration clause, Kolkata High Court appointed an arbitrator. Death order in the set aside by the Honorable Supreme Court. And well, another point is relying upon BGS judgment. BGS relying upon BGS judgment, and this judgment, Bombay High Court recently decided similar matter.
What judgment? BTS?
Well, BGS, SGS, Thomas Devi, and NSPC Limited.
This thick one? Oh, what is it? Okay, this is different. This is relied by you.
No, my land is applied.
Okay, okay. Not given to me till now. So he's going ahead of you now. Yes, what about this judgment?
Well, kindly have a look. Like, judgment decided by the Bombay High Court.
Bombay.
Similar matter.
Prior, before going to this BGS judgment, you know,
Well, BGS judgment is clear. Bombay High Court is
Okay.
protected. Yes.
Yes.
Well, paragraph 7 and 8 of Bombay High Court. It says 11 January 2020.
Yes. Out here, the part of the, out here, the part of the cause of action was under the Calcutta High Court.
Yes,
And
follow it, yes, and it is mentioned that my agreement was operated in Kolkata. That's why not operate Kolkata High Court has the jurisdiction to appoint arbitrator, not Bombay High Court. And here in our case also,
no, but then out here, it is also said that the arbitration proceedings shall be conducted at Kolkata.
not at Kolkata. That's why as because earlier also one petition was moved before the Kolkata. That's why yes.
So out here, facts are slightly different. I mean,
In our High Court also one petition is already decided out of the agreement. This agreement was already decided one writ petition. Like,
Huh?
well, now our projection may be happening.
no, let us see the Supreme Court judgment only pertains to that.
Yes.
Yes, that's only the pre-judgment
Yes.
judgment, which has been again relied by the Supreme Court and clarified also.
Uh-huh.
It's there in recently as reflected.
But one thing we have to clarify. I think the seat of arbitration and the venue of
Yeah,
arbitration is different.
Your lordship, if it sees the previous judgment.
Hey, wait, let it finish.
Yes, yes.
Let it finish.
Well, DGS also relied upon this judgment, which one we are relying on.
We are relying on.
So DGS here in case references. So our case is very in support of this judgment is very much clear that
Okay, wait. In this Ravi Ranjan developers.
Harshad Aditya Kumar
Okay, okay, okay. These three judgments you are relying on.
Lord.
So according to them, you should approach the Mumbai High Court.
Yes, Lord.
Now, according to you, as per the agreement,
Yes.
the place of business is here.
Yes. Positive action is here.
Other action is here.
Earlier one writ petition also disposed of by the Honorable Court out of the same agreement by law.
And what about Mumbai? Is there anything there? Any cause, part of cause of action is there? Is the part of cause of action there?
No one.
Nothing.
Our registered
No,
office is
the registered office is here and he is representing my land friend is representing Guwahati office. And our all notice delivered at Guwahati, not in Mumbai.
Cause of action in Guwahati and the agreement made in Guwahati.
At Khataniapara village, that village, particular village, at Khataniapara, within the jurisdiction of Darang district.
Made in Assam, basically.
Lord.
Made in Darang district.
Yes. Very relevant is paragraph 19 for us of this judgment. As because here is said that
Which judgment?
Ravi Ranjan developer,
Ravi Ranjan. Para
para 19 lordship.
19.
Here is said that lordship, which one jurisdictional defect is happened pursuant to consent also, and such a defect cannot be cured even by consent of the parties regarding jurisdiction. Maybe consent at all.
That's all.
Applies. maybe the lordship. The lordship, I would just like to read the arbitration clause last line. The arbitration shall be held at Mumbai.
Where?
I am stressing at the words shall because the Supreme Court also considered the word shall. I will take that. One doesn't aspect. And second aspect, I have thought it, we are a tower erecting company, cellular mobile tower erecting company. So we have a standard contract which are the same clauses are there in other contracts also. And since I have relied on the judgment that which I have already placed your lordship that Brahmami River Affiliate Limited, and relying on that judgment, this honorable court on similar clause has also sent the arbitration to the respective court. That judgment I have placed your lordship, the Guwahati High Court also. Last time.
Last time,
Yes, I have one more copy of it.
it's not here. Wait,
We are the responsible time giving one more copy. So this honorable court also relied on the Brahmami River Palace Limit. And the lordship subsequently, the full bench, three judge bench court of the Supreme Court relied on BGS. Had
out here, it has said that it was held where the seat of arbitration is mentioned.
placed, it was placed,
Out here, I think wrong use of the word.
but it was placed.
Because I think there's a difference between the word seat and
That has
venue.
been said. This aspect has been considered by the Honorable Supreme Court in the case of BGS, SGS Sumar, which has been relied subsequently again by the Supreme Court. And in both these cases, they have discussed even Brahmami village, which have upheld the.
Where is that up? Where does it say?
Your Lordship, I am straight away placing the recent one, this BBR, BBR India Private Limited. The citation is 2023 1 SEC 693.
My God, yes, okay.
This I am relying only one judgment. Your Lord.
No, what about
Brahmami-
this? What about this constitution bench judgment? Interplay between arbitration
Yes, yes.
agreement?
This subsequent judgment, they discusses this, so I am placing the both
Okay,
together.
okay.
They will quote the judgment. Your Lordship may see paragraph 60.
Para 16.
Yes. 2000. No, 2001. May I read your Lordship? This will deal with party autonomy, whether the cause of action is, whether should have any connection with the seat, and subsequently the interplay when the parties have not used the word seat, but have used the
The word
venue.
venue.
Then what is the conflict?
Okay, very good. This is a 4 judges bench, no, 2 judges bench.
This is true, but your Lordship will see 16, paragraph 16.
Yes.
Noticing the interpretation of three bench judge of this court in BGS, SGS Sumar. They are relying on the BGS with,
Yes,
I'm relying and also he has.
Yes.
Has observed that the expression subject to arbitration used in clause E to subsection 1 of section 2 of the act cannot be confused with the subject matter of the suit. The definition of court. The term subject matter of the suit in the said provision is confined to part 1.
part 1 of,
The purpose of
part
the
1 meaning,
part 1 and part 2, your lordship. The part, because the definition of court comes in in part 1, that is clause 2, 1E.
E.
But they are saying the subject matter of the suit and the subject matter of arbitration are both different things.
Correct.
So one should not be confused with the cause of action.
Ah.
One should see what is the subject matter of the arbitration. That is, they have to see clause 20. They should not see the subject matter of the suit as if where the contract was signed, where the cause of action arose. Because the court, the jurisdiction of the court has to be decided keeping in mind section 20. And there are three parts, 1, 2, and 3. The purpose of the clause is to identify the courts having supervisory control over the judicial proceeding. Hence, the clause refers to a court, which should be essentially a court of seat of the arbitration process. According clause E of subsection 1 of clause 2 has to be construed, keeping in mind the provision of section 20 of the Act, which are in fact determinative and relevant when we decide the question of C of the arbitration. This interpretation recognizes the principle of party autonomy, which is the edifice of arbitration. In other words, the term court, as defined in clause E to subsection 1 of section 2, which refers to the subject matter of the arbitration, is not necessarily used as final determinative of the court's territorial jurisdiction to entertain proceedings under the Act. In BGS SGS Sumar, this court observed that any construction of the provision would render section 20 of the Act nugatory.
In view of this court, the legislature has given jurisdiction to two courts. The courts which should have jurisdiction where the cause of action is located, and the court where the arbitration takes place. That is important. This is necessary as on some occasion, the agreement may provide the seat of arbitration that would be neutral to both the parties. The courts where the arbitration takes place would be required to exercise supervisory control over the arbitral process. The seat of arbitration need not be the place where any cause of action has arisen, in the sense that the seat of arbitration may be different from the place where obligations are had to be performed under the contract. In such circumstances, both the courts should have jurisdiction, the courts within whose jurisdiction the subject matter of the suit is situated, and the courts within whose subject matter of the dispute resolution forum. Now, your lordship, if the seat is decided, then definitely that court will have jurisdiction. However, in our case, it's the place shall. So, if instead of reading entire thing, your lordship, if I can come over to next
In
page,
your case, it says the venue.
it says the place, the arbitration shall be held at Mumbai, shall be held. Because there is a difference. What the Supreme Court is saying when they use words like this, the intention was the entire.
The seat
arbitration
would be, the
held
seat would be there.
It's not a individual session. or
So, okay,
something.
supposing instead of shall be held at Mumbai, supposing it says that the venue shall be at Mumbai, then what happens?
Then also same. Because the intention was the entire proceeding of arbitration would be connected with that place. It's not that a sitting of arbitration is connected. If the intention is one sitting, say
So we will have to gauge the intention
intent. That is-
after looking at the contract agreement.
Yes, your lordship, and how to look at the intention is also given. If your lordship
Okay.
we come to paragraph 25. That para I had read, your lordship, to say the party autonomy and the cause of action has nothing to do with the seat of arbitration.
Just a minute. Okay, then, next. So what do we say, already? The seat of arbitration need not be?
Need not be a place where the cause of action arise. The party has full autonomy to decide if it is neutral. That is the basis of arbitration. Otherwise, the
The,
party.
the place of arbitration can be anywhere.
Anywhere.
Only the seat will have to be as per the terms of the contract. That should be.
No,
What?
no,
Can the seat be, can there be a consent with regard to where the seat should be? When there's already in place
Yeah.
an arbitration clause providing where the
Seat
seat
is-
should be.
Yes, that's what my submission is. What he is trying to say is that since cause of action has not arises at Bombay, I think that submission is totally fallacious, because the seat can be at a place where cause of action need not arise. Because the Arbitration Act gives autonomy to the party to decide even a neutral place or seat or venue. Otherwise, autonomy given to parties would be come down to nuggetry, redundant. That's what the Supreme Court says.
What were you saying just now?
The word that uses nuggetry,
Where?
17.
Yeah.
Any other construction of the provision would render the section 20 of the Act nugget. So while interpreting court in as defined in the definition 2(1)(e),
So you mean power should be given to the parties?
parties, and the parties have already decided. My submission is that this clause is a clause of 21, not 21(3).
To decide the seat of arbitration
Yes,
in terms of
in terms of 21,
21
subsection 1.
and not under 26. Yes, then
Lordship, may I then take your lordship to paragraph 25? Because in between it discusses if there is if the use of the word is seat, then definitely there is no confusion.
Ah.
That court will only have jurisdiction. But what if they use the word venue? That is at para 25.
Okay.
Because this was discussed in BGA, the three judgment, which is again discussed here in this
Yes.
present case, where the Supreme Court. According to BGS HS Suma, the law applicable where the parties by agreement have not fixed the jurisdictional seat is crystallized as under. On a conspectus of the aforesaid judgment, because they discuss all the judgment, including this judgment, Your Honor. Brahmami River Pillar.
Yes.
On a conspectus of the aforesaid judgment, it may be concluded that whenever there is a designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceeding, the expression arbitration proceeding would make it clear that the venue is really the seat of arbitration proceeding, as the aforesaid expression does not include just one or more individual or particular hearing, but the arbitration proceeding as a whole. That's what my submission is.
So the venue can be anywhere,
Yes.
but it will still be under the jurisdiction of that particular seat.
Seat. And they have used that even if they use a word like place, the aforesaid expression does would make it clear that the venue is really the seat of the arbitration. As the aforesaid expression does not include just one or more individual or particular hearing, but the arbitration proceeding as a whole, including the making of an award at that place. This language has to be contrasted with the language such as tribunals are to meet or to have witnesses, experts, or the parties where only hearings are to take place in the venue, which may lead to the conclusion, other things being equal, that the venue society is not the seat of the arbitration proceeding, but only a convenient place of where they have to be specific. Here, the thing is the place of arbitration shall be at home. That's what I'm stressing on.
Okay.
Further, the fact that the arbitration proceeding shall be at a particular venue would also indicate that the parties intended to anchor arbitral proceedings to a particular place, signifying thereby that the place is the seat of arbitration. So that is how the
Now the only issue is, okay, now in your case, Mumbai is the seat according to you. Now, the appointment of an arbitrator, does it have to be by the court in Mumbai?
yes. Even
Because,
they will-
because, huh?
Yes. Even the Bimami Pillar clarifies that.
Does it say here in this case?
See, it doesn't say it that, but it says a seat. Once that seat is there, then the entire supervisory jurisdiction of that court, including 11,
Including
11,
of
6.
11.6.
No, and secondly, Your Lordship, if they have difficulty, this is just not to be recorded. Once the arbitrator is appointed, they can request for online hearing, they can request for a venue for certain some other place also. That's different. That's a subject to consent of all the parties therein. But difficulty is not the reason for not going to this subjecting to oneself to the jurisdiction of that or that's courts of the where the seat. Difficulty cannot be. Otherwise, the basis of arbitration agreement would become null. Because they had agreed knowingly very well, they have signed this agreement.
But what about this other judgment? That constitution bench judgment? Anything out here?
The constitution bench judgment is discussed in this year. This is a
Where has it been discussed?
para 25 Your Lordship. The BBR that I have read now.
No?
Just now the paragraph that I have read, Your Lordship. In BBR 2023 judgment.
In PPR?
Yes. The one I have just read.
What is the name of this case?
Which one?
This, where the Justice Chandrachud, Sanjay Kishan called PR Gawai.
This
This is with regard to the interplay between the Arbitration Act and the Indian Stamp Act.
This is Your Lordship, even if this, I think there's a recent judgment which says that even if the arbitration agreement is not stamped also, then one has to give an
So this has nothing to do with this case. So who gave me this?
I think.
Didn't you?
I have relied Your Lordship, Bimami Pillar, then BGS, which is a three bench. Then this BBR,
You have given me this BPR.
Yes.
Then Babin Sharma. No, Babin Sharma is.
Bhavan Sharma is also relying because it's our High Court instead relied on Bimami Pillar.
Okay, yes.
Brahman.
And then you have given the Brahmani River.
Yes.
And so these three judgments.
And also BGS, because BGS, I'm not quoting BGS because BGS has been quoted in the subsequent 2003.
BGS has been quoted by you also.
Yes, sir.
For
Paragraph
you
fif-
petitioner, you have quoted which para?
59.
59.
Yes.
And respondent has quoted
Yeah, Roshan.
BGS
BGS, I'm relying on paragraph 82.
82. And
And
with,
in
huh?
and in BBR, the subsequent one,
Yes,
I'm relying on 16, 17,
25.
and 20.
Brahmani River on 8th, para 18.
Yes, the last
18 is.
18, 19, and 20.
And you are relying upon Ravi Ranjan.
Ravi Ranjan, Bachchi.
Ravi Ranjan, which para?
Paragraph mostly 19,
90.
45,
And then
45,
45.
and then 48.
48. And you are relying upon who is this Hyundai?
Mumbai, yes, well, one Mumbai is as well.
No, Hyundai Construction.
Sorry.
Hyundai Construction.
Yes, well, we are relying upon.
You are relying
Paragraph-
upon that. Also.
Yes, well, paragraph
7 and 8.
8.
And you are relying also on these two judgments only. Only these two, correct? No.
Yes.
One more judgment.
Yes.
Okay, you're relying only on these two judgments.
Okay.
These two, I mean three in a way. Three judgments relying upon 4. It will take some time. I've got some CAV. Have to be, I cannot dispose of now. No time. No time.
Emirate, our projection from our petition, Lordship, paragraph 13. Paragraph 13. And 19 of our petition. 13 and this is our projection.
Maybe this pen is not working. Give me a red one. It's not working. Yeah, red one.
And my lord, from
Yes,
from BGS, from one more paragraph we are relying on.
yes.
Paragraph 43.
So you're relying on 43 and 59.
Yes. And very interestingly, which one we are relying upon, and my learned friend is relying upon that Brahmani. Comprised bench is his lordship Justice as Bopanna. Here is also as
I noticed.
lordship.
That's what I was thinking. What's happening?
And in paragraph 45, three judges best judgment is there. Here also his lordship Justice as Bopanna.
Right.
Apply.
What to do? Y'all with the eagle eyes, you'll have noticed all that. And then the entire problem comes to us. Because there's a conflict.
Confusion is there.
Conflict is there.
Yes, but,
Conflict is there.
and my
There
learned
is a
friend,
slight conflict, no doubt.
my learned friend is saying that the petitioner signed the agreement. The dotted lines agreement, put, put before the petitioner to be signed. He signed. Moreover,
These are
in
high
our-
commercial, that I will object to. These are high commercial, these are.
And
nothing
those,
commercial.
anyway, those
That's fine.
cannot be, those cannot be taken into account.
but very initially,
It's not-
We have done it with open eyes, that's a
But-
different thing.
it's
But
very-
in,
Doing
anyway,
very well, they are getting hired.
no, there is a conflict, no doubt. But then it seems to be, it
has been
appears to be
resolved.
prima facie, it appears to be resolved.
Yes, but- And the mobile tower which is installed there, now day by day is getting cut down. Anyway,
Which company?
TTL.
GTL, these are infrastructure, these are not cellular,
Early-
as in they.
Lordship, it was earlier it was executed with my Aircel company. Aircel company sold out its infrastructure just to CNIL. CNIL merged with GTL. Now, this is the case. And the mobile tower getting carved out.
But paragraph 25 has resolved it.
I hope so. Otherwise, you'll have to wait a very long time. Heard, Mr.
Care of it.
Learned Counsel for the petitioner. And Mr.
Harsha.
R. Sharma for the respondent. Hearing concluded, judgment reserved. It'll take some time, at least, well, this weekend, not very busy, at least 2 weeks, I think.
Problem.
No time.
Oblige,
The issue is there, already there, but.
Much of.
oblige.
What is this? Arbitration 35, what is it? Oh, the. Okay, you put this in the file. Don't put in there, not in there. No. You put the small one in the paper, and the smaller. Yes. Mr. Gogoi, he wants license.
Yes, Your Lordship, but the rule does not provide that. Rule 25,
How can you demand something? Say that I have to be given.
Earlier,
That is their restriction.
to the 16, my lord,
Huh?
earlier act, my lord.
Huh?
Earlier
Earlier.
rule, my lord, very restricted to have to both the license.
Huh?
Both the, one person cannot have two licenses.
As per the 2000,
2017, there is an amendment,
where
Amendment, my
you
lord.
can have both the license, correct?
594.
No, you can have. As per the rule allows you to have 2 licenses, correct?
Fine.
But then unless they give you permission or the license,
Fine.
how can you demand that you have to be given? Where is the rule that says that you have to have, that a person who has the IMFL license can, the country liquor license should also be given the IMFL license?
there is no rule. Your Lordship.
Now, my lord, after amendment, my lord, the IMFL license holder given by amendment, my lord, they are also allowed to have the
Country,
spirit license.
but country has not been allowed.
No, not allowed. Those of
That is the law laid down by them.
my lord,
Unless you say that unless you ask that the law should be read down or you want to challenge the law, the rule. Where's the scope?
my lord, my lord, on several
No,
occasions,
Mr. Counsel, please understand.
my lord,
The issue is not about this or that, your personal problem. Your case is because of the amendment in the law,
Right.
the IMFL retail license holders are now also getting the country liquor license. However, the thing is not going the reverse way. That means the country liquor license holders are not being given the additional
I am a-
IMFL license. Where is your right? Where is your right? Show me your right to have that liquor license, MFL license.
no, my lord, by amendment, my lord, 595.
Okay.
All existing IMFL manufacturers, IMFL.
Mr. Counsel, only you two have the law. I'm who's going to write the order. I don't have anything.
Page 305.
Yeah.
305, sub rule 5, Your
So,
Lordship.
sub
I've
rule
highlighted.
all existing IMFL manufacturers, IMFL wholesale warehouses and IMFL and county spirit
594.
59. Page 305, my lord. This several 59. All existing IMFL manufacturers, IMFL wholesale warehouses, IMFL and county spirit retail licenses having a valid license shall be eligible to apply for county spirit wholesale and county
So have you, yeah, their applications have been submitted to you?
my lord.
There is a some representation, Lord. A simple representation.
And on the basis
No, you see, Mr. Council, so first of all, is there a form by which this have to be applied for?
no, my lord,
Is there an application format?
no comment pattern.
It's
On the basis of,
Huh?
on the basis of our persistent representation before the
Ah.
authorities, my lord.
Ah.
On 35/2022, the government has issued a letter to the Commissioner of Excise, whereby they requested to submit a report on the feasibility of demand faced by the association.
Hmm.
Thereafter, my
That
lord,
has not been done.
there has not.
They are already running a country liquor retail like.
No, you take a decision on that. That's all there. We cannot grant this petition.
Fine.
No right, as on date. But then you have got to take a decision on their application. Have you submitted representations
My
for
lord.
grant of license?
My lord.
Because it says that they can apply. Once they apply, then you have to take a decision.
We'll take a decision on.
Okay, right. Heard, Mr.
Jail of
J. Laskar, learned counsel for the petitioners, and Mr. R. Gogoi, learned counsel for the respondent. The petitioner number 1 is a registered association whose members are having license for retail sale of country liquor. The petitioner number 2 is the secretary of the petitioner number 1. The petitioners have approached this court by way of the writ petition, praying for a direction to be issued to the respondent authorities to grant IMFL retail sale license,
It's an offline.
Huh?
Offline.
MFL off license, to the members of the petitioner number 1 association. In terms of Rule 59, 594, bracket 5 of the Assam Excise Rules, 2015. Correct? Next para. The petitioner's counsel submits that the petitioners have submitted applications for grant of the country liquor sale, have applied for licenses for sale of country liquor to the respondent authorities,
not considered.
Huh?
IMFL.
or, sorry, IMFL of licenses, with the respondent authorities, and in person to the same. Where is that order?
My lord, page 50, 35.
And in person to the same, comma, the joint secretary to the government of the SAM, comma, excise department had written a letter to the joint secretary to the government of the SAM. How can it?
Written to my
It had written to the commissioner of excise, comma, Assam. By letter dated, by letter number EX full stop 220/2022/4 dated 30/05/22. Requesting him to submit a report on the feasibility of the demand raised by the petitioner. Next para, the petitioner's counsel submits that no report has been made on the feasibility of the demands raised by the petitioners by the respondent number
Two, my two.
two. Tilde. He accordingly submits that a directive should be issued to the respondent number two. Take a decision on the to submit a report on the feasibility of the demand raised by the petitioner in terms of the above letter dated 35/22. So, six of Mr. R.R. Gogoi, parent counsel for the respondent, both respondents submit that he has got no objection to the prayer made by the petitioner. Mr. In view of the consent of the parties, the Commissioner of Excise, bracket respondent number two, is directed to submit a report on the feasibility of the demand raised by the petitioner for grant of IMFL off license in terms of the rule 594 /5 of the SM Excise Rule 2000 and the petitioner's representation submitted. The feasibility report should be submitted by the respondent number two to the Joint Secretary to the Government of Assam Excise Department within a period of 1 month from the date of receipt of 1 month is enough report. Is it enough? 1 month?
Enough, I know, 35,000.
From
2022.
a period of 1 month from the date of receipt of a certified copy of the report. Full stop. Thereafter, the respondent number two should also communicate, should also send the report of the feasibility report to the petitioner. That is petitions accordingly. Right.
May I submit one to the law?
And before that, before we dispose of it, they send the report, send the copy of the report to the petitioner and take a decision on the petitioner's representation. And that, yes, but
May I submit one thing on rule 594 says that existing IMFL manufacturers, IMFL wholesale warehouse, IMFL country split retail licensee within bracket mall holders can apply for country splitting. And he's already a country split license holder. We cannot get this rule is the
okay, the other way, I'll just change
the
it.
other way.
I'll just change. You have to make, I'll give you a decision later.
All right, Lord.
20. And with regard to item number 7, my lord, the record will be required, but the tourism council record is not available with
Just
them.
a minute, just a minute. You take this photo, just, they're going to take it back. Just take it back. Just say, it's, rule 594, bracket, no, just take rule 594. Rule 594, bracket 5 of the Assam Excise Rule 2016 states as follows. Just take it up. Okay. Then I'll give it. Yeah. 594.5.
Item
Yes.
number 7, my lord, hearing matter, my lord. The council for the tourism department, my lord, the record will be required, but record is not required.
Item 7.
7. Record would be
Why are we
required.
on item 7?
That is with regard to non-payment of
18 to 20.
that record would be required, my lord.
So why are you mentioning now?
No, my lord, because the council has come and the record is not been there. So without the record, my lord, hearing won't be possible.
Let it come, you cannot
Let it
jump.
come.
I'm sorry, this notice. 18 to 20. Huh?
Let me check. Well, in respect of three markets in the district of Dharam, there was a chaotic situation while the tenders were put in the tender process.
Yeah, for whom? Yeah, for the response number 8.
I am the beneficiary, Milord. Market has been settled in my favor, Milord. Milord, before my learned friend start, Milord, what has happened, Milord, pursuant to an order of this honorable court regarding the dispute during the course of the tender process, Milord, there is a direction to the deputy commissioner to
Initiate inquiry.
an inquiry, Milord, and that inquiry has been done. A report has also been, Milord, provided to them, but that report is not under challenge.
No need.
Why?
That report is not in their favor.
No, Milord, that report is not in their favor. Why?
Let us see the report. You've got the report. No.
Yeah.
Yes. You go and make photocopy.
Fine.
Just tell to make photocopy. Have you got another copy?
My lord, we have another one.
Only one. None for your friend.
Only
My lord, I can provide.
You're the private response number 8. And this has, and you got it. Government has it or not? Government doesn't have. Only you have it. This is a frequent situation,
My lord,
very powerful.
No, my lord, this is the situation in these three cases. Almost
Ah.
1 crore rupees have been siphoned away. And
Anyway,
proof from
please photocopy it. Wait. Let him photocopy. Now you can get photocopy.
my lord, we'll go to that. I'll just take 5 minutes to
Yes,
read
yes.
the case.
Photocopy abhi. 2 copies. Jaldi. 2 copies.
I can give it. We have a copy.
You've got. Oh, then make 1 copy. Tell him 1 copy. For the government, we'll give the government. The government doesn't have.
Government has also.
Okay, so, yeah, no, let him read.
My lord,
So what does it say basically? I have not read.
my lord, basically, the basic point over here, what is they are saying? They are agreeing to the content of this writ petition are saying that from the 10 o'clock, it was supposed to start. The putting the bids in the tender, process, but it started at 1.
Okay.
If it started 1, which we admit, because it was there in our writ petition, still, why we couldn't submit the bid inside the box between that 1 to 2? That's what I understood. He's agreeing. My
2 is
allegation,
the last. The 2 is the. Okay, you can submit it till 2 o'clock.
yes. What I said that it was in the, as far as the tender notice is concerned,
So they are saying that yes, you were prevented from submitting from 10 to 1.
indirectly, yes. Malad, now I'll give you the scenario, Malad. I'll take only 5 minutes.
No,
because
I get it.
Yeah.
Basically, your case is that you could not submit your bid in time. And supposing the earlier settlement had been made at say 30 lakhs, supposing it has been settled with them for 2 lakhs.
Yes,
That
exactly,
is your case.
exactly. My lord, another peculiar,
While your bid was around say 28, 29 lakhs.
my lord,
That
what
is
I-
your case.
another thing I would like to add, my lord. My lord, almost 25 years I am handling this kind of market cases. This is the most peculiar case where I have found that instead of 10 o'clock, 1 o'clock box was
Box was?
it was placed.
Ah.
Okay. My lord, it was such a peculiar situation. Suppose we are one group of the tenderers. We know because it will be, petitioners did not know it will be placed at 1. Other side knew it was placed at 1. So they were in such a position, as soon as the box was placed, they were in line. And my lord, it was such a scenario, it was not a closed envelope that they put in. Over there in front of the box when they go, they pick out the papers from the envelope. They go one by one. Means instead of putting in and just going out, no, they take around 10 minutes. And ultimately what happened, my lord? Suppose 5 of us are in the round, in the line. The first one goes, as the first one goes, another 6th one comes in between that line. And during that period, I have given the documents during that period, informed over the phone to the Deputy Commissioner's office, to the CEO, saying that this is going on. And please allow us to submit
And what is the job of the 6th person?
the 6,
The 6th person?
2 o'clock should be over.
So he will delay the,
It was totally delaying tactics. And
any other tactic, please tell us. We want to learn also.
Yes, sir.
Any other tactic, we might after retirement, get in that line also.
Luckily, we don't have retirement, my lord.
We have.
We may start before that.
We want to know because we don't want to get, locked also. Yes, Mr. Who's the query for the government? You give one copy to the petitioner? Government, have you got your copy?
No.
Give it to him. Give it to him. Government, that's the respondent number 8 will give it to him. Respondent number 8 will give that to him, not a problem. No, it's okay. It's okay.
My lord.
You read.
Incidentally, private respondent got all the information from the office.
Government doesn't have.
Government doesn't have anyone, we don't have. We are the agreed person.
So I don't know. So we have to ask the government, I think, for all the government answers. I mean, we've got to ask the respondent number 8 as to what the government will say,
Yes.
according to you.
Yes.
Correct. Okay, that is one aspect. Supposing we accept your explanation. What about his allegation that for the previous year, the settlement had been made, say, around 30 lakhs? And you had given him, you had settled the market with him for around 2 lakhs.
My lord, in the first,
Who is the authority who awards the settlement?
my lord, this executive officer,
Who is he? Where is he?
my lord, he,
You, under you.
and his report and deputy commissioner's reports are contrary, my lord. He is the person main.
Is that correct?
He is the person who did
I-
everything.
Is the stand taken by the petitioner correct? That earlier, for earlier, it was around, two, it was around 23.33 lakhs, the settlement for the first matter. And you settled it for 2,46,000. No, that was, sorry, that was your offer.
Yeah.
Your offer was 23 lakh, but it was settled earlier for 20 lakhs or something.
Now 22 lakhs, 22,222.
Ah, 22 lakhs something.
That is.
But you have settled it for 2,46,000. Is that correct? No, that is not that is another issue. Why? Have the prices of things gone down? It's a cattle market. Have the prices of cattle gone down? Not that. So I think we list it on Friday. You bring all the original records. I want the rates with which the market was settled prior to 1,723. You give the settlement of the market for the last 2 years.
My lord, I've given
Prior
the
to-
comparative statement.
Where is that?
My lord, is my lord is with 4312.
I'm with all.
Acha. Would your lordship be pleased to see 4312? That is the
Yes.
first page.
Para.
My lord,
Where is the chart?
para 17, paragraph 17, page 15. Settlement value.
No, this I got.
Yes.
Now you see, you have said settlement. Okay. Yes. So in all the writ petitions, para 17.
In one, it is page para 19. And my lord, this in this petition,
What about 20, 21, 22? You don't have the rate.
my lord, I don't have it, but it was like that only, like that.
Okay. Yes. Yes, Mr. Yes, yeah, who's appearing? Yeah, appearing for the PNRD, correct? Okay. Because, yes, Mr. What have you got to say?
My lord, my submission is very limited, my lord. So this writ petitioner, my lord, was not intending to deposit their tender. These are all afterthoughts that a manufactured statement has been made. Now, my lord, with all respect what I am submitting, my lord, a person who has not participated voluntarily in a tender process, now can he come before my lord and challenging?
No, he's saying that he was not allowed
No,
to
my lord, these
participate.
are the disputed question of facts, my lord. He was not allowed or, my lord.
That is one aspect.
That is, my lord, that has been examined by the deputy commissioner and it is available in the report, my lord. Now we have. to follow
When was the
report,
tender, last date of tender?
my lord.
My lord, last date of tender was, my lord, it was only one day,
What is the date?
6/6.
6/6.
6/6.
Yes, my lord.
When did you come to this court?
My lord, on
July.
no. In June 28, the first order was passed by this honorable court, where all the three writ petitioner was there. At that time, we did not know the scenario as to the price and everything. We all three got together and came before this honorable court.
No, Mr. Counsel. You are wrong.
My lord, page 62.
7, 8. No, you see, Mr. Counsel, the High Court gives a seal when you file the,
No, this is the second writ petition.
okay, there's earlier
Yes. That is the order over there, 62, where the
page. 62.
page 62, my lord, annexure 11. All these three writ petitioners were together at that point of time.
Okay, okay. $28.
Paragraph 7 is relevant, my lord. Page 66.
23. But when did you file it?
My lord, it will be in that writ petition, my lord. We came immediately, my lord.
Okay, anyway, you get the thing. You see, one thing is, how come you're allowing such a drastic fall of the rate? From 22 last year, it was settled for 22 lakhs. Now you're giving him for 2.46 lakhs.
My lord, another market, last year it was 64 lakhs. This time only 8 lakhs and my bid, which I,
In another case.
in another case. And in the other case, it was last year 23 lakhs, they have given it for 6
Okay, right.
lakhs.
Heard Mr. J. Abadin, Leonard Counsel for the petitioner. Also heard Mr. P. Andy for PNRD and Mr. M. Chetia for respond number 2. Mr. A.R. Bhujan appears for the respond number 8. The petitioner grievance is that he had not been allowed to submit his bid.
Restrained from submitting.
Was restrained from submitting his bid as the box for submission of the bid document was not available when he went to put the bid, when he went to deposit the bid document. Not available, correct?
No, madam. The fact remains, instead of 10 o'clock, 1 o'clock, the bid box was there. And before I was not.
Acha, what have I said? That he was not able to submit his bid in view of the fact that there was not enough time to put his bid document into the box. The reason being that the reason was due to not enough time being given to the large number of bidders who wanted to submit their bid document.
And instead of 10 o'clock, it was placed at 1 o'clock.
He submits that as per this report. He submits that as per the report made by the Office of the Deputy Commissioner Mongol Darang, dated 10/8/23. The box in which the bid documents were to be submitted was to be
Was placed at 10.
was to be placed at 10 a.m. However, the same was placed only from 1 p.m.
No, the report says it was placed at 10 a.m. but the process starts from 1 p.m. Paragraph 1 of context. Last page starting.
My lord, there is no process.
Acha, what have I said? What have I said? That's the last. There was not enough time to put. To the bidders to submit their bid document. To stop. He submits that as per the a report dated 10/8/2023 passed by the Deputy Commissioner's Office, Darang, in persons to. No, don't forget that. In persons to cut. Though the box for submission of bid had been placed outside the office at 10 a.m., tender documents could be dropped only from 1 p.m.
I deny one, which I deny in my paragraph C.
Full stop. Next para. The petitioner had initially made a challenge by WPC 3689/2020 regarding his inability to submit his bid document. Full stop.
Honorable Lord, could you please to see para 8 of that order, man? What I have categorically stated at that point of time.
Just a minute, Mr. Council, I'm passing an order. You don't disturb all the time. Very well said. Full stop. However, WPC 3689/2023 was disposed of by order dated 28/6/23 with the direction being issued to the Deputy Commissioner Dara to make a report with regard to the grievance of the petitioner. As such, the present report has been made. The present report dated 10/8/23 has been made, correct? 10/8/23.
Yes, my lord, it is last date 10/8/26.
Then this has, now only it has been produced. Huh?
So long. And that is 10/26.
When was it last? When was the last order? 11.
On that day also report was not there with the government. When the last date came, my lord.
He's got it. He's kept it in his file.
No,
No, no.
but my friend said the report is out.
No, my lord, we have also received recently.
Anyway, now what to do? You look into this properly. List, the respondent, the Mr. P. Handy shall obtain instruction with regard to section para 17 of the writ petition and bring the record to verify whether the settlement of the market and then to verify the rate, the bid slash rate for which the market had been settled for the year 2022, 23 and 21, 22. Then same order in all this. This is the matter on when. That is to. It's in para 17 in all or para 17 in para 18 you said in one case.
In para 19 in one case, my lord.
Which one?
Repetition
Common order, pass a common.
4293.
Common order, just call it. 17, no, just say para 19 in. Para 19 in.
Para 19 in, my lord, repetition 4309.
4309.
Otherwise in para 17.
Para 17 in that serial number 18 and 19 and in serial number 20, para 19.
19.
Okay. Correct. The issue is basically money. There's a issue of, there can be an issue of connivance, there can be an issue of cartel, because I find that that the allegation is that none of the tenderers had submitted beyond 3 lakh.
That's the reason I said one group.
Now, if you see, there's a thing of cartel, where a group of persons, in common furtherance of an intention to lower the price, they do all this. Happens,
Happen.
and happens a lot.
Malad, another thing I'd like to just say, there is nothing called after putting the ballot box. There is no process at all. Everybody comes and drops. That's all. I don't know why they are saying 10 o'clock it was placed and till 1 o'clock the process was there. If the process was there, then you extend the time. Malad, today, we please to have a copy of this deputy commissioner's report.
We give it to you.
No, this is not the one. They have given that the person who created all the problems that the executive officer's report.
I made the photocopy for you only.
I haven't.
Since the government is not providing anyone anything,
that
only
one copy-
respond.
That one copy was incidentally given to the government because they were handicapped, so it was given to the government.
Okay, next.
Obliged, deeply obliged.
Yes,
Let's review my lot application. My lord.
yes, what is your case?
If ordered lordship,
Where is the letters that you're relying upon?
yes, my lord, that lordship will find. But, first, my lord, my selections, my lord, has been interfered with, my lord.
Huh?
My selection for the post of my lord, Town Prodan has been interfered.
Ah,
My lord, 2 grounds.
Ah.
That is, my lord, the read petitioners, my lord, which my lord, son of the earlier Town Prodan, my lord, has not provided the mark being under column, my lord, G of the advertisement. Is an, my lord, entitled trademark, my lord, being a son of the earlier Town Prodan. That was the pleaded case of the petitioners that no mark has been provided to the petitioners, my lord. And this honorable court, my lord, interfered on one of the grounds that the mark has not been provided, being the son of the earlier Town. And secondly, my lord, another ground, my lord, is that though, my lord, I have resigned from the post of my lord, member of a Panchayat, my lord, but I had not resigned from the, my lord, membership of the political party, my lord. I belong to, my lord, and that's why, my lord, this honorable court only on 2 grounds, my lord, interfered with the, my lord, selections of the, my lord, privy petition. Now, my lord, I have applied, my lord, RTI, my lord. That documents I have received is 107, my lord.
oh, you have received, you didn't have copy.
My lord. Lord, you
Yes.
will find 107.
Yes,
My lord, this is the RTI documents, my lord. Next, lordship will find 171, my lord. This is the final evaluation sheet that was produced during the proceeding, my lord. And the subsequent one, lordship will find 172.
So the other person has been selected or has been appointed?
No, my. That's for my confidential order has been passed.
So you're the respondent number 8.
Yes, I am the.
So the case is that you had not resigned from the political party.
This is one of the aspects, my lord, and another, my lord, the point that is honorable.
He had not been given mark
Yes, my lord. That lord.
as being the son of the
Yes, earlier governor.
earlier governor. And then
That lordship will find 172, my lord. First lordship will find 171. This is the final evaluation bit. That was produced during the, my lord, bid process.
yes, 172 what?
Yes, my lord. 172 is the individual evaluation sheet of the member. 3 members are there, my lord. This is, my lord, selection board, my lord.
So
Yeah.
who are you? Who are you?
I am the number 2, my lord.
Number 1 also same name.
One, no, my lord. One is the lordship will find in the column number. Is Gao Pradhan, family members, Stoke, Muzadar view, 10 marks. Lordship got it, my lord. That 10 marks has been provided to the number 1, my lord. That is the, my lord, read.
No, name of candidate at page 172.
Yes, my lord. Name of the
At
candidate.
number 1, name of candidate is Sanpara Prabhat. Correct?
No, name of the candidate is wrongly written, my lord.
No, this is what do you mean?
Yes,
No, no,
my lord. Then lordship may call for the record.
no,
my
no,
lord.
no, this is not a, sorry.
Yes, my lord.
this,
I have
yeah,
put, my
yeah.
lord. This is the
Huh?
evaluation sheet, my lord. The column is wrongly written, but name is there, my lord. Lordship
What?
will find in the name of the village lot that wherein the name of the, my lord.
Okay, what is this Sanpara Prabhat? This Sanpara Prabhat is the village
Name of the
lot.
Yes, my lord.
So Keshab Chandra Baisya,
Yes, this is the repeat.
that is the petitioner.
Yes, read petition.
And you are Kandar
Conduct of
Baisya.
The read petitioner lordship will find 10 marks has been provided, my lord.
Oh.
And my lord, in the second one, my lord, the review petitioner, no marks, my lord, 0 marks has been provided. Next page, lordship will find.
But why did this court say that no marks were provided?
Because
to him?
lordship will find in the 171, my lord.
Yes.
171. This is the final evaluation sheet, my lord. There has been also quoted in the judgment also, my lord. And lordship will find in the judgment, this is the read petitioner assembly provided. That page 163, my lord.
Okay, that is one aspect. But what about that?
Resignation, my lord. Yes, that, my lord, I could not produce during that time, my lord, because I have misplaced it, my lord. And that, my lord, I have resigned, my lord, from the political party on, my lord, 25/11/21.
Where is that page?
Page 175 is the, my lord, type copy, and the, my lord, vernacular 1176. This is the only two grounds, my lord.
I do not know whether this is a correct document or. There's a question of fact now. This is a new document.
Yes, ma'am. Yes, my lord, order 47, rule 1, my lord. Review, my lord, can be, my lord.
Can be, but then you had all the opportunity to produce this document. This was the basic case of the petitioner.
But my lord, my lord, it is admitted fact, and it is also finding of.
This is your fact,
Yes.
nobody else's fact.
Yes.
Not an admitted fact. Admitted fact by you only, not admitted by the other side.
But
This for
my
the
lord,
petitioner.
facts
Great
remains that,
petitioner.
my lord, I have resigned, my lord.
Yes, what have you got to say?
Case is on the two
Two points.
on that the two document has been brought up. Under the maintenance of the review matter, the 3 grounds are there as per the Honorable Supreme Court. Well, the discovery of new document that has to be satisfied that whether exercising due diligence, he could not produce this document. It is his personal law, the personal document. He find it from the personal file. There is no statement that after exercising due diligence, he could not produce this document before the Honorable. This is all come absolutely after thought. And my lord, they against me
Huh?
that I am misleading the court in that question. But they have not annexed my additional affidavit, which I have filed in the writ petition, my lord, annexing the final evaluation sheet. I have
And it-
stated in my additional affidavit that only the final evaluation sheet has been provided to me in reply of my RTA application. My lord, how when he has not annexed the RTI application by which he got this documents, my I have provided on the final level. Sir. How the individual marks have been provided by RTI application to him, my lord? That is after the judgment of this honorable court, my lord.
That's why, my lord.
Whether when he has filed the RTI application, my lord, after passing of this honorable court's order, my lord, whom debarred from him to file RTI application before. My lord, this is my pleading case that I have not been.
Where is your RTI application?
My lord,
Not annexed.
171. Sorry, 170, 170, my lord. This is the, my lord, letter by which the application has been brought. That's why, my lord, the record may be called for, my lord. Whether,
When he has filed the RTI application,
my lord, record may be called for, my lord, regarding the selections, my lord.
No.
Whether these documents is available in the record or not, my lord. That will be, my lord, the better.
My lord, first he satisfied the.
Regarding, my lord,
the ground, my
selections,
lord.
if they disputed that the mark has been provided, had not been provided to the, my lord, writ petitioner, then lordship may call for the record, my lord, of the selection.
My lord, the only at ground number D, he stated that on the sole ground that only sole ground that he is not a member of the political party. This honorable court interfered this court. Ground number D matter in his review application matter. That is on merit. Erroneous decision cannot be corrected by the review petition, my lord.
Ground number D.
D, my lord.
Ground number D. Which page?
D, my lord. Page
23.
23, my lord.
Huh?
Page 23.
Yes.
Page 23. For that, honorable court has set aside the selection of the review petitioner as Gampradhan of the Sanpara village by notice the being ancestor solely relying on the fact that the review petitioner had not resigned from the political party belonged to at the time of his selection as Gampradhan, though having only resigned from the membership of the Gaon Panchayat. But the,
Which ground?
my lord, and the marks, my lord, that is on the merit. First, he has to satisfy that he is eligible. On the eligibility ground, his selection has been set aside. The document which his resignation, this not come under the rule 1, my lord, because it is his personal knowledge, my lord. There is no discovery of new fact, my lord, new thing. Who knows? So, lordship, my lord,
In order 47, rule 1, my lord, it is also there that would not or is there, my lord.
My lord,
If I may
paragraph 20,
allow
my
to
lord.
read, my lord.
Discovery of new and important matter or evidence which after exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him.
Yes, or could not be produced at the time when the decree was passed or order made, my lord.
After exercise of due
It is
diligence.
order, my lord, or it is written or, my lord.
So wherein you stated that after due diligence, you were not able to
My
produce.
lord, yes, my lord, that lordship will find, my lord. Yes, page 20, my lord. Paragraph number 18, my lord. So, my lord, due diligence word was not used, my lord. My lord, may I read, my lord? The review petitioner explains that the review petitioner has resigned from the membership of Bharatiya Janata Party on 25/11/21. The review petitioner on 25/11/21 submitted his resignation letter from the membership of Bharatiya Janata Party before the president, 242 number booth committee Bangkok under Soalkuchi Mandal of Bharatiya Janata Party and the president, 242 number booth committee Bharatiya Janata Party Soalkuchi Mandal. 87 number of Bangkok government that accepted resignations of the review petitioner and released the review petitioner from the membership of Bharatiya Janata Party on 25/11/21. Therefore, the review petitioner was not a member of Bharatiya Janata Party from 25/11/21. The review petitioner could not annex the state resignation letter dated 25/11/21 in his ability position filed in the petition number so and so. As
Yes.
My lord,
my lord,
he has not even noticed.
The judgment.
Yes,
What
my lord,
do
page page paragraph 20 and the review will be maintainable. Paragraph 20. In view of the above matter, the following rules are maintained as listed by the executive, and the review will be maintainable. Discovery of new and important matter or evidence which, after exercise of due diligence, was not within the knowledge of the petitioner or could not be produced by him. And when the review matter may not be maintainable matter,
Is there any discussion on the words after exercise of due diligence?
yes.
Yes.
Paragraph 33. Is the perusal of the amendment made in the second set of review petition matter shows that there is no explanation offered regarding discovery of new material in the form of documents sought to be filed. When it is the case of the respondents themselves that the relevant documents were all along available in the relevant record and they had already filed xerox copies thereof during the second revision proceeding, they can hardly be hard to state that the said documents were unknown to them and were unavailable for being produced before the learned single judge prior to passing of the common judgment in order to explain it. It is evident from the above that the respondents had not discovered any new material for them to have moved a second set of review petition in order to satisfy the requirement prescribed in order 47 rule 1 CPC. It is imperative for a party to establish that discovery of new material or evidence was neither within its knowledge when the degree was passed, nor could the party have laid its hands on such documents evidence after having exercised due diligence prior to passing of the order. What to speak of conclusive proof of having undertaken an excessive due diligence for accessing the relevant documents, there is not an averment made by the respondents in the second set of review petition to the effect that they could not trace the documents in question earlier or that they had made sincere efforts to obtain certified copies thereof before common order detention was passed, but could do so for some caution and validity. And here is my lord, in our case, my lord, in his affidavit in opposition, my lord, there is no such statement. Rather, he denied the averment that he is a member of the political party. That is the, if your lordship kindly see the affidavit in opposition filed by him, my lord.
Okay, let us see the writ petition.
He has annexed in the review.
Yeah, okay. It's okay, no need. Where? Wait. Why don't you file an affidavit?
My lord.
Why don't you file an affidavit? Yeah, yes. You put all the, where is it, para? Anyway, page. Let us see what is the stand taken in this affidavit of the. One 36.
It's 56.
86, 96 is by respondent number 8.
Yes.
What does it say,
In regard, my lord,
Tara?
my lord, para 10. In review application. Para 10, my lord, as regards the statement in paragraph 9 of the requisition, that deponent begs to state that though he was the elected member of the number science of Bangsar Gamasar and won the election from the ward number 4 of the state panchayat, he offered his resignation on so before the president and the secretary of Etonom Gaon Panchayat. Thereafter, the state president secretary forwarded the resignation letter from the deponent to the block development officer, 12 development block, for taking necessary action in that regard. Thereafter, the block development officer, 12 development block, submitted his said resignation letter to the executive officer, Kamrud Parishad, at letter date 20th for favor of information and necessary action in respect of the deponent resignation as ward member of ward number 4 of the Bangsar Gaon. As such, it is apparent that the deponent resigned from the post of member of the ward number 4 of 87 of Bangsar Gaon. Hence, the averments of the petition in the said paragraph are stoutly denied. My lord, kindly see my paragraph 9, my lord, in the petition. Paragraph 9, at page 11.
Yeah.
That the petitioner begs to state that respondent number 8 is an elected panchayat ward member of Etonom Bangsar Gaon Panchayat, and he being an active member of a political party, that is Bharatiya Janata Party, had contested and won the election held in the month of December 2018 as the BJP candidate from the ward number 4 of 87 of Bangsar Gaon Panchayat. It is stated that when the notice select list was issued, publishing the name of the respondent number 8 as selected for the post of Gaon Pradhan for village Sanpara Parbat, the president of 87 of Bangsar Gaon Panchayat has issued a letter dated 25/5/2022 addressed to the Sualkosi block development officer Sualkosi, forwarding a letter dated 22/5/2022 submitted by the respondent number 8, wherein he seeks resignation from the post of member.
So, my lord, I am
The-
denying
he-
the membership of the Bharatiya Janata Party.
My lord,
That is, my lord, wrong.
My lord, my averments was, my lord,
Denied.
it's a active member.
Yes,
lord,
that
for the-
denied, my lord. I
That
have
was my
denied.
case, my lord. But he was no mention he is a member, rather he sternly denied the averment.
Yes, denied means I am not the member of the Bharatiya Janata Party, my lord. I have denied that part.
He was silent. And he could have said that I had resigned, but I have misplaced that in the affidavit in opposition, my lord. It is his personal knowledge, my lord, personal document.
He has only denied that he resigned from the panchayat. Is it?
No, he admitted,
I have
he resigned from the, therefore your lordship has held that the resignation from the post of membership does not mean that resignation from the
Correct.
political. That is complete afterthought. It is personal document.
That's all.
my lord, I am
First,
resigning.
first he satisfied that point, then the other document.
But what about the other portion regarding marks given by the marks given for your
Being a member of.
being a member of the
Pradhan
Pradhan family?
Right.
What about that
Yeah.
document?
My lord, in his ground number, my lord, without calling for the record, this honorable court has come to erroneous conclusion. The erroneous decision cannot be corrected in a review petition. It is.
Apparent on the
in-
face of the record, my lord.
I have submitted the, my lord, judgment, my lord, in that, my lord, where the review is not maintainable, my lord.
Page para.
Para 20, my lord, para 20, stop point 2, my.
So do you agree that you were given marks? Now, do you agree that you were given marks as the family of the Gaon Pradhan? What have you got to say? I'm not on the law. I'm on fact.
My lord, now it appears from that personal sheet, my lord. Even there, in that mark, there is overriding, some overriding.
I don't know. So you don't agree. You file a reply affidavit. Okay.
My lord, till then, my lord, record may be, my lord.
Huh?
The record of these elections, my
No,
lord,
my
may be
lord,
called
this
for.
is the
If they are disputing, my lord, that part.
This is,
If they are disputing that part, my lord, then record of the elections is required.
my lord, my submission, humble submission, my lord. This, my lord, the first document, this document is not making. And subsequent, also the second document
That-
also, he has to show that he, prior to passing of this order, he exercised his due diligence to obtain that. The respondent were represented, but they have also.
No, but in the first document with regard to mark is because you did not submit that document in your petition.
And
You were not aware of it.
I have not been provided, my lord, I have.
So you have been provided now. With regard to that mark. With regard to the other aspect, political party aspect, that can be decided separate. But what about the first part?
It is from the, it is on the record, but the other point, my lord, point first is he must be eligible. He must be eligible, my lord.
There's a roadblock in there's a roadblock ahead of you, huh? But yes, on the question of, because on one question, but then I want to decide both the issues. What have you got to say on that aspect? Do you want to make a reply? Do you want me to dispose of this matter? I can dispose of it, can go either way.
My lord, therefore, earlier occasion, I want to file my affidavit in reply. I will file.
Okay, fine. Okay. Right, Mr. R. Sarma, Learned Counsel for the review petition. Mr. S. K. Roy, Learned Counsel for the petitioner. Now, issue notice.
No, my lord.
No,
I
okay.
have not made any
Mr. S. K. Roy, submit that he would like to file an affidavit
on the maintenance.
on the maintainability of the petition. Praise allowed. 3 weeks time is granted. Please the matter of the 3 weeks.
All right.
Obliged.
Yes, keep it inside. Yes,
Yes, my lord, I am issuing for the note 6, my lord. Only 2 weeks time may be granted for filing affidavit, my lord.
The question, what case was opened by? After perusal of record, only record the hearing.
the cause have come. He has not taken steps, madam.
We have taken that, we have.
No, no, if you read the order, it says in addition to the above. It says here, petitioner takes steps for service of notice upon them by a registered post with AD within 2 days. In addition to the above, petitioner will take steps.
These services, they have received the. They have submitted an affidavit.
But they have not appeared. Yeah, have you appeared?
And note 6, my lord.
No, no, it's for 2, 4, and 7.
Yes, Lordship, but Lordship, they have received, they have chosen not to appear, Lordship. They have received, Lordship, on Lordship.
I don't know, when there is an order by this for a direction to do both, you have got to do both. You have got to do both. It says here, in addition to the above, petitioner to take steps. You have got to do both. Yeah, you are appearing for whom?
My lord, the state, PNR.
Yes, so you have brought the record.
I have the record.
Is there is the submission made by the petitioner process correct?
No, my lord. In fact, we have a detailed inquiry report. My lord would like to peruse it.
Let them see it also, so that they can make submission on it. You see? What is it?
Lordship, Lordship,
Then-
2 forms were submitted. And they were,
Okay.
Lordship, overriding. Lordship, that has been admitted. And also the other allegation that the same surety was given for another market, even that has been admitted.
Huh? Yes.
Lordship, same surety, Lordship, the piece of land was given for
yes.
surety in another big market,
Another rate.
in another market center. Lordship.
But
Lordship,
there's a
that-
twist, there's a small twist in the facts, but what had happened initially is that the private business had submitted
And
his bid, his bid. There was a tender which was released on 11th of April 2023, and he had submitted his bid. So when his bid was initially submitted, his bid amount was 2,92,000. After the due process had taken place and was sent to the Zilla Parishad because it was more than 1 lakh, at the level of the Zilla Parishad, my lord, someone had erased the original bid amount of 2,92,000 and had written 99,999. So when the private respondent found out that that someone has fudged his bid, he filed an application before the CEO that someone has manipulated my bid amount, and according to the CEO asked the deputy CEO to do an inquiry. And post that inquiry, my lord, he has filed an inquiry report, which is there
Okay.
in the original report. So there he is giving the entire narration of the basically implicate the president that there's no wrongdoing on his part. The chances that the president might have fudged. This is the detailed version of it.
your name is Hemachandra.
No.
Hemchandra.
petitioner,
It's not. I can be better.
Okay. No, these two bids that is submitted is for the same market.
same draft.
But here this is for another market also.
This present list is concerned with the Paschim Mangaldoy Anchalik Panchayat, Deo Nagaon weekly market. We are limited to this.
2 points.
Paschim Mangalday.
Deo Nagaon weekly market under Ramhari Gaon Panchayat, which is under the Paschim Mangaldoy Anchalik Panchayat. The Deo Nagaon is where the action.
So you are also a guarantor for Jijir Palm Market.
He was,
Separate.
Violates clause 14 of the tender.
Huh?
Clearly violates clause 14 of the tender.
but that market did not vote in favor of that particular individual
For which he was the
of
candidate.
which he was a candidate.
Okay, it did not go.
It didn't go to. That finding is also there.
But where does it say out here that he was allowed to submit a fresh?
There is another parawise bench, which is at the first page of the records method. First, that's in English. Parawise comments which have been given. Third page. Third page. From there, the parawise comments are there. Para 7 and 14 are very relevant method. Decided very. The explanation given in para 7 and 14. Give the entire detailed chain of events. But thereafter, he was given another chance to even file and
Yes, there seems to be a explanation.
Lordship, the explanation is the lordship came later on, but it's not a part of the record. That the response number 6 was asked to submit the second form. There's some later on as an explanation.
What do you mean?
Lordship, that the response number 6 was asked to submit the second form because the previous form was and mishandled lordship with the white blood. Lordship, it's not a part of the record, lordship. As your lordship can see that it's only a part of the paragraph. Lordship, it can be a cooked up story also, lordship.
That maybe a cooked up story, but how do we prove that it's cooked up? That is the issue.
Possible lordship, if a tender form has been lordship corrected later on by an official, lordship, this is a clear case of fraud. And lordship, if
No,
this thing-
it's not been corrected. They are saying that
lordship,
the he,
amount has been changed, lordship.
but he's saying that he had made the complaint.
Lordship,
You had
the
made a
petitioner had made a complaint regarding.
petitioner had made the complaint.
Petitioner also had made a complaint, lordship.
So he also made a complaint that
And
it was
lordship,
released.
they should have done a retender in this case. Not allowed the response number 6 to allow a fresh form, lordship, because lordship will open a floodgate, lordship. Any tender will come, lordship will change the amount, then they'll be allowed to submit a new form.
But
This is an
these
open
are disputed questions of fact matter.
So, lordship, on the face of it, lordship, a fraud has been committed by an officer and at whose behest, lordship, that has not been found out till now. Fraud has been committed, lordship.
But in fact, he has directly go ahead and complain that people have fudged with my tender. Kindly redress my grievances. I agree the petitioner as a law-abiding citizen, he has made a complaint, but he has
He has a
also
legitimate
equally made a
grievance.
complaint.
As a lordship, as a participant, lordship, who has been deprived because of a fraud committed by someone, not as a law-abiding citizen.
But at the end of the day, madam, he has also complained, you have complained, and the highest bidder has been given the
Lordship,
tender.
entire process is vitiated by fraud in this case, lordship. At the most, there should have been a retender, lordship. Lordship, in any tender, lordship, no two tender forms can be allowed to be submitted, lordship.
But in fact,
Lordship, it will open up a floodgate in this case, lordship.
But what to do? It will, sometimes things happen.
And lordship, not a part of record, and in the record, nothing has been lordship given as the at whose behest the lordship, the officer and that has corrected the amount. Nothing has been given in the record.
These are disputed questions of that method. If my learned friend says it's a disputed or a cooked up story,
But if,
who will testify about
but if
it?
they are just joining the dots as to what has happened.
The sky is the limit.
But my submission is
Conspiracy theories are to be.
Lordship, a fraudulent tender process cannot be allowed to be.
No, but fraudulent by whom? At the end of the day, that's corrected. He said that my documents have been fudged. And there was an inquiry done and they found that it was fudged, but by whom they don't know.
There's another way of looking at Lordship, maybe at his thought they had corrected.
Okay, let me ask you,
Made a complaint, Lordship.
okay, at the time of opening, was there two tenders submitted by him?
Who tender found this?
Initially, he had submitted his bid after he found out that there was some budget with his original bid.
No, that was after the opening or prior to the opening?
After the
It will be, it just found that the by private value. Overwriting by someone in the office paper and found that it will offer better the correct.
When did you find that there was overwriting in your bid?
Hello, I filed my complaint by lord. Before settlement by lord, on my lord,
but that is there in that comment, otherwise comment.
on 6/7/2023, I complaint.
When was the NIT's date? What is the date of the NIT? 11/4/23. What was the last date of submission?
6/6/2023.
6/6. When was the tenders opened?
Close of the middle of the
Probably on 6/6/23.
Same day, my lord.
same day.
And then when did you submit your complaint?
Complaint my lord, I came to know my lord that the tender has some wrong has been done. Then on 6/7/2023, I submitted complaint. Report a civil to that.
On 6/7.
6/7. Till then, no settlement was given. Therefore, was submitted to the laboratory.
Because yes, you see what they're saying in out here is that at the time of opening the tender, his tender was found to be 2.92 correctly. Only later on, after the file was kept with the officials, they found that some
Fudging has been done.
Lordship,
fudging has been.
there are two comparative statements. In one comparative statement, record number six amount was 99,000. In the second comparative statement, it came out that the amount is 292.
That second comparative statement was issued after he was allowed a second opportunity to give.
Subsequently, that is what they are saying.
Lordship, he made a complaint, Lordship, after the petitioner had lodged the complaint that there is.
Madam, there is one
That
aspect.
is a tariff.
At the time of opening of the tender, all the tenderers are supposed to be there. And they would have known straight away on 6 June 2023 if there was two tenders submitted by one person. Now your writ petition has been filed sometime in end of January 2020. Now you took more than 6 months.
Lordship, actually the work order came out in the month of 23.
No, I'm not on that. On 6 June itself, you should have known, you would have known if there were two tenders submitted by him.
Related.
What did you, is it your case that on the date of opening, there were two tenders submitted by him? It's not your case.
At the best, Lordship, Lordship can stay the work order issue. And Lordship, let the government, Lordship, run the market because the fraudulent tender process can never be, Lordship, end out.
My lord, this is on the
Yeah,
verge of
the problem is these are disputed cases are tough. Right, Mr. P. Barwa, Learned Counsel for the petition. Also heard Mr.
P handling,
P. Handy for
PNR.
PNRT department. And Mr. P. Raman for the point number. The petitioner's case is that subsequent to, that pursuant to and NIT dated 11/4/2023 for settlement of the Deonagan weekly market run by the Paschim Mangalday Anchalik Panchayat, the petitioner and the respondent, number 6, amongst others, submitted their tender. The the petitioners, the petitioners further cases the respondent number 6 had submitted two bids, one amounting to rupees 2,92,000, while the other bid was for rupees 99,999. The settlement of the market, something market, na, for the year 2023-24. Okay. That is from 1/7/23 to 30/06/20. Then I have said the particular for the case is that the respondent number 6 submitted two bids. The other amounting to rupees 99. So, however, the same bank draft number 029034 dated 6/6/22 has been used by the respondent number 6 in both the bids. The next para, the petitioners counsel submits that the same bank draft cannot be used as earnest money while submitting two bids for the same tender, which in itself is illegal and not as per the tender laws of tender, as per the laws. The petitioner's counsel just submits. No, the petitioner's counsel submits that. The petitioner, on the other hand, had submitted a bid price of rupees 99,999. The petitioner's counsel submits that as fraud has been committed by the respondent number 6 as per the facts stated above. The settlement of the market with the petitioner for the year 2023-24, that is from 1/7/23 to 30/6/24, should be satisfied. Mr. P. Hundick, Learned Counsel for PNRD, has produced the record. I'll pass. I'll complete the order later. I'm doing the tape. No problem. Yeah, I'll keep the record. With.
Maybe your lordship.
Yes.
Nothing has been served by Dasi Service Owner Bhattano 4, 5, and 6. I filed an affidavit of service. In response number 4, his wife has received the copy. Sorry. Sorry. I said in paragraph number 4 and 5.
And notice be served on the wife.
Yes. But he was not present, everyone.
It's half on like my.
Huh? What is?
Extra मतलब CPC वाला notice half on life is not.
As for order of 5, any elder member of family. Order of 5.
There is a judgment of this court. I think Justice Surana has passed some order.
As per order of 5, any adult member of the family, and if it is in case of lady, between 10 to 5.
I think Justice Surana has passed an order against. What do you think?
As far as CPC, it is individual.
Anyway, what is your yes? What is your case? Yes, what is your destruction?
Hello, I am not a Malo, I am actually a Comel party Malo. Amburi municipal, but that is the main party. He is not party. Then he is the municipal of capital, he is Malo, he is not a PI. Another case is also picked on 15 man. So arising out of the same context, Malo, same tender.
But the parties are defined in different context.
Parties are defined, Malo.
And what
Arising
is
out
work?
of the same context, Malo. Item is defined, Malo. In this case, Malo, item is no other is Malo item number 1. In our
This is different matter. It is different matter.
not defined, Malo.
What is
Same matter, Malo.
Where is the original? Where is the Xerox?
What is there?
Why should you keep the original? Why should you keep it? You're supposed to file that. Who are these persons?
Ruby Gogoi is the wife of response number 6. And 5 is your lordship, Amguin Municipal Board. So 4, 5 is executive officer.
Or executive officer who has received.
4 is Amguin Municipal Board. 5 is executive officer.
Who is the wife? Which one is the wife?
6, Ruby Gogoi.
Who is the
That's preference number 6.
if they are absent? Can we do anything?
Let it be on 15, my lord. My lord.
Oh, let us see 15.
So, my lord, justice service has been
Right.
allowed.
Heard Mr. S.R. Goyal has gone for the petitioner who submits that justice service has been affected on the respondent number 4, 5, and 6. He submits that the wife of the respondent number 6 has received notice from their respondent number. However, no one appears for the respondent number 4, 5, and 6. Mr. F. Chetty appears for the respondent number 1 to 3.
Yeah, 1 to 3.
As analogous matter is listed on 15, list the matter of 15.
Wait, visit your lordship. And the Paris last order 13/5/2019.
Yes.
By this order, Lordship, the records of this particular agreement or the communications were directed to be kept at handy by the respondent.
Yes, who's
But
the parent?
information, these records were not.
What happened, my lord? Yesterday, getting from the senior, take a call or from a advocate who they will take time. Because we could not put.
From maybe some other.
Anyway, my lord, we are searching the record. Otherwise, government has filed affidavit with the opposition.
But the court has asked you to get the record.
My lord, that is there, my lord. However, that time the council, who was the council, we are still pressing up the record, my lord. Not in the file.
How much was the entire amount?
Entire amount was 3 crores 78 lakhs 37,806, but till at present due was 63 lakhs something. 63 lakhs 9,596 along with the interest because it is from the 2012.
Interest on what basis? As per the agreement or what?
As per the Lordship,
You cannot make, this is a writ court. No, no interest.
record is required Lordship because the disputed all are we have
Hey,
filed.
what to do? We have to adjourn the matter.
Yes,
to-
Lordship.
Right.
Let us sort it.
Miss
And so
N.
totally.
Chaudhary appears for the petitioner. Petitioner. Mr. G. Bokaila submits that. He needs time to produce the record as they are searching for it. Accordingly, this matter. After,
Can it be a Lordship on 22 February?
not this one.
Because Lordship, the case is of 2013. Lordship.
Maybe, madam, it's been chapter 2013, what to do? If the records are there, I won't mind disposing it. It's a matter of it.
Okay.
It is a lot. This matter will give some time, my lord. The present status of the land, my lord. We have not communicated with the parties. My lord.
Yes, to the parent. What's your name?
S.I. Taluk.
Heard Mr.
S.I. Talukdar.
S.I. Talukdar, Learned Counsel for the petition. Who submits that the critic from the synopsis. I begin break, okay? The petition number 1 has nothing. Next para. The petitioner's counsel submits that the Matia Anchalik Panchayat has been running the Dupa Para Hut. Hut is what? Market? Slash market on their land without, on their land and had also constructed the Matia Medical Sub Center on the lands of the petition. Though the petitioners had allowed the Matia Anchalik Panchayat to run the hut temporarily comma. The petitioners are not willing to allow the Anchalik Panchayat to run their hut on the petitioner's land any longer. The petitioners thus pray that the respondent should either acquire their land under which law? Acquire their land and pay compensation for the same, or in the alternative, to pay monthly rent. Is it? It's monthly rent to the petitioner for use of their land. Sutta. Next. The affidavit filed by the respondent number 5 has admitted to the fact that the Dupara weekly market is being run by the Anchalik Panchayat on the land of the petitioners for almost 50 years without any objection from the landowner. As such, the question of forceful occupation of the petitioner's land does not arise. In para 12 of the affidavit submitted by the respondent number 5, it has also been stated that the place of the weekly market may be shifted to government land without harming the petition. So stop. Next para. The affidavit filed by the respondent number 3 is to the effect that the Dupara weekly market run by the Matia Anchalik Panchayat after getting the approval from the Zira Parishad for the last 50 years, without any objection from the landholders or from the public. It, however, states that the market covers government land, 100.5 biga, covers government land measuring 1.5 biga, along with the land of the petitioner. They also, respondent number 3 in his affidavit has also stated at para 30 that the Matia Anchalik Panchayat has not encroached upon the land of the petitioner, and the place of the weekly market will be shifted to government land without harming the petitioner.
Resident inspectors were not granted.
Okay, first up. At this stage, the petitioner's counsel prays for adjournment to ascertain the status of the petitioner. Yes,
My lord, there's an affidavit, my lord, on behalf of the technical officer, my lord, CEO.
respondent number,
CEO is. Three.
he have admitted to occupying his land.
My lord, as far as affidavit.
So why don't you acquire his land? Or pay monthly rent,
My lord, that,
or you move out.
my lord, there is government land also.
Government land, forget it. Government land so is real land. But that just because you are using government land does not give you the right to encroach upon his land.
But that verification the circle officer has to give whether the market is actually being done on the government land right now or it is encroaching on his land.
Here affidavit of respondent number 5 or 3 has specifically stated is being run on government land and his land, to a small portion of his land. So this is not a disputed question of fact. This is a fact.
No, that's a fact.
Only thing is the area that is being encroached upon. It will be shifted, it will be really shifted, that's a different issue. But you obtain instructions whether you want to pursue this matter.
Yes, ma'am.
Because there are only 3 available options. One is you ask for acquisition or they move out. So, and number 3 is whether you want monthly rent. So supposing you say you want them to acquire the land, but they take a decision that no, we are going to move out. If that is okay with you. Okay. What have I said? Full stop. The prayers allowed. The petitioner's counsel shall also appear instructions as to which of the 3 options is preferred by the petition. Namely acquisition of the land. Number 2, vacation of the land by the Anchalik Panchayat. And 3, monthly rent to be given by the Anchalik Panchayat. Anchalik Panchayat. List the matter. After? Oh, no. List the matter after 2 weeks. No further adjournment, Mr. Counsel.
It please it okay. Look, here we can challenge to matter labor force total. No, other council not represented.
Then what to do? Can we decide?
Matter. Service is completed also.
Okay. Service is complete.
We have take that. The take of the case is that much.
Just a minute. Right. Mr.
HP Gwala.
HP.
Right.
Out here MP. Your HP.
HP Gwala.
HP Gwala appears for the petition. No one appears for the respondent. Even though notice has been deemed to be served upon the respondent. No, and even though the order dated 19/6/2018 that service on the respondents is complete. Yes, what is your case?
The railway authority issued a circular dated 9/10/2003 for the purpose
9 the circular
9
dated 9/10/23.
9/10/2003
2003. Yes.
for the purpose of restructuring of the grade C and D employee post In this process, some higher post extended and some lower post reduced
This will take some consideration. What is your case basically?
Basically, they have challenged this notification that
all the, my lord, Kedar are not get the benefit, my lord.
What
Right.
benefit?
My lord, reconstructing, my lord, promoting, my lord, by reconstructing, my lord, and
Reconstructing?
restructuring the, my lord,
Restructuring, yes, not reconstructing.
Right. Restructuring grade C and D employed in railway, my lord. For, my lord, strengthening, my lord, and, my lord, rationalizing, my lord, the, my lord, stop pattern, my lord, in the railway stop, my lord.
So what is the challenge based on?
Based on, my lord, all the employees are not get the benefit, my lord.
What benefit?
My lord, the promotion benefit, my lord.
What is the benefit that is
My lord,
supposed to
in
be?
that process, my lord, we have, my lord, extended, my lord, some higher post, my lord, and reducing, my lord, some, my lord, lower post, my lord.
What is the rule? What is the promotion process? What is the benefit? You tell me that.
My lord,
Don't tell me that he eats breakfast. Everyone, what does he eat for breakfast? Does he eat puri bhaji or does he eat toast? What? Rice? What?
The employees are artisan cadre, my lord.
Okay.
Artisan cadre, my lord, different, my lord, they have instructed, my lord, different, my lord, some different grade, my lord, collectively called, my lord, artisan, my lord, cadre, my lord. Grade 1, grade 3, and, my lord, these, my lord, trade of platters,
I
my
think we'll adjourn the matter. No time. List the matter after 3 weeks.
liability below.
Yes.
My lord, matter pertains to cancellation of fair price option.
Yes.
My lord, on the basis of allegation raised by some beneficiary, my lord, is
Raised by?
some beneficiary, card holder, FIC card holder,
Cancel.
cancel,
Cancel when?
cancel the license of the petitioner, my lord, that is on 22 January 2015. At page 17,
Where is the cancellation order?
cancellation order at page 17,
70.
1 second.
Okay.
Yes, my lord.
This is suspension order, Mr.
Yes, my
Doctor.
lord. This is, my lord, this order, suspension order has been passed by the deputy director, my deputy commissioner of the district. And, my lord, thereafter the petitioner approached it from the High Court by challenging the
Against this order.
order. Yes. Thereafter, my lord.
Where is that?
Thereafter, my lord, the
No, where is the
Block.
WPC?
block that is disposed of.
Maybe, but you filed the, what was the decision?
Page 19, my lord. That was disposed of, my lord, last paragraph. If the appeal is filed by the petitioner on or before 31, above that paragraph, though clause 29 does not provide for condonation of delay in preparing an appeal, I am of the considered opinion that ends of justice is the after each the petitioner is permitted to file an appeal on or before 31st July 2016. Again, the order dated 22/1/2016 before the appellate authority. So thereafter, the petitioner approached the appellate authority. Upper Assam Commissioner, my lord, at Guwahati. And my lord, that appeal there, my lord, was my lord referred to, again referred to Deputy, my lord, Director, come Deputy.
Where is the appeal order?
Appeal order at page 83, cancellation.
So, where your appeal, where is the decision on the appeal?
Appeal, my lord, appeal, that is at page 86. 80.
You see, Mr. Constable, you have made a challenge against the suspension order.
Yes.
Correct. Then the suspension order was decided, so that appeal against the suspension order, where is that decision?
Suspension, against the suspension order, he approved this court, my lord. Thereafter, the,
And this court said you go in appeal.
yes, my lord, as per
Then-
clause 29, my lord.
Then you went in
He
29.
made an appeal before the, my lord, Commissioner, Upper Assam, my lord, at Durhat. And the appeal, one of the findings of the appeal, my lord, that is at page 86. That order also, my lord, the appeal was, my lord, decided by the deputy minister. Same capacity, both suspend the license.
Okay. So the suspension order was passed by Deputy Commissioner
Deputy commissioner.
and appeal,
Appeal also, my lord,
appeal was dismissed,
cancelled.
rejected,
License has been cancelled.
rejected and okay.
My lord, after suspension, my lord, the license, my lord, cannot restore exceed 90 days. As per clause, my lord, 10 of the
Anyway, that is gone. Now your license has been cancelled.
cancel, yes. And
So you're challenging this.
Yes.
What does 29 say?
29, my lord, at page 29 C, at page 29, my lord, if
Page
the order
20.
is made by the deputy commissioner, appeal to the commission. And we follow this, my lord. Page 29.
Yes.
But it highly verifying if it been in reply. I've filed on the order.
Affidavit in reply. Affidavit in opposition. You mean?
On the order for 6.
Affidavit response number 6.
6. Just B.
P is there. 6.
I am Spantilal Tuhani.
Sorry.
Just filed on 11/5/17.
I don't know what affidavit, do you have it?
Yes, my,
Affidavit of?
I have received the copy. Affidavit filed by the referendum, private referendum, 11/5/2013.
Affidavit in reply filed by the respondent. Affidavit in reply? Oh, you are like using wrong words. Affidavit in opposition. Cannot be affidavit in reply. Affidavit in reply has to be filed by the petitioner.
My lord,
Yes, which paragraph?
my lord, and it's the paragraph 2, 3, 4, and 5. This 4 paragraph will focus everything what has happened in this case. Actually, the REIT code is not the code of city. To decide all issues afresh, hence it is not tenable. So in this case, at the very purpose thing is that whether it's tenable or not.
Mr. Kaushal, the first thing is, he has challenged his suspension order.
I will come to it.
No, you have to come to that now. You
Yes.
cannot jump, you cannot build the fourth story without
No.
constructing the first story.
Whatever they say, that is itself from the judgment passed by AK Vishwami.
Let us see the
73
judgment passed by
pages.
this court at page 18. Let us see the judgment passed by this court, page 18.
Page
18.
18. Here. But the judgment is here. Wait a minute. Second paragraph. The REIT petition directed against an order dated 22/1/15 issued under clause 15(1) of the Assam Public Distribution of Articles Order 82. For short, the 82 order suspending the public
The
distribu-
suspension of the PDS license is under challenge. Okay. Now, what does the court say?
court said
Though clause
Yes,
29.
though clause 29 does not provide for condonation or delay in preparing an appeal, I am of the confident opinion that ends of justice will be served if the petition is permitted to file an appeal on or before 31/15
Before the appellate authority.
years against the order dated 22
Yes.
April.
So against the
before
order
the
of
authority. Yes,
against the order of suspension.
Yes.
Now, the order of suspension was issued by whom?
uh,
Deputy
Direct.
Director. Okay, he's the Deputy Commissioner.
Deputy
Oh,
Director comes, my lord, I see deputy commissioner, my lord, I see deputy director.
Huh?
Yes,
Deputy Director in charge food and civil supplies. No.
he is the.
This is not Deputy Commissioner.
He is the deputy commissioner.
Huh?
Who is that?
Deputy Director in charge. He's the Deputy Director in charge.
That power empowered upon deputy commissioner. That's for my understanding.
Your understanding will not do. We'll have to see what the law says.
Yes, my lord.
Let us go to 29 again. No, that,
yes. Page 17 is the Deputy Director, IC Food and Civil Supply and Consumer Affairs Bureau. Deputy Director.
okay, yes. There is nothing wrong with the order.
Yeah.
Because it says if an order is made to any officer, if order is made by any officer lower in rank than the Deputy Commissioner, appeal to the Deputy Commissioner.
Yeah, Deputy.
So there's nothing wrong with the I'm not talking about the merits of the order, cancellation order, but the appeal has been rightly heard by the Deputy Commissioner.
Now, see paragraph 4.
Yes.
That a REIT petitioner filed an appeal before the appellate authority in conformity to the order 1750. Then, before the Commissioner Upper Assam at Jorhat. And the Commissioner Upper Assam Jorhat responded the appeal, right number so and so, along with the case record to the Deputy Commissioner Dibur for entertaining to dispose of and order dated 34/15. Very important matter. The Deputy Commissioner Dibrugarh passed the order on 14/8/15 after hearing the parties passed the order on 15/8/15. The repetition is for the same grievance, again approaching the Honorable High Court by way of filing the present.
No, he can challenge. There's no issue. He can challenge it. But the issue is when there's an alternative remedy available. So, if
Whether read
when the order has been issued by the Deputy Commissioner, as per page 29,
Yes.
your appeal should lie before the Commissioner and go to the Commissioner. Or because this is a disputed question of fact, I think. What is the ground of challenge to the cancellation order?
My lord, the allegation offered against the petitioner, that was totally false.
What was the
They are-
allegation?
They are not the totally beneficiary of that fair price offer. They are outsider buyer. They filed a complaint.
Saying that they did not receive their ration.
Yes. They are not the, my lord, beneficiary of that
So
particular.
can this rate court decide that issue?
Not my lord, newly created a new license, my lord. That some persons in connivance with the some official, my lord. This complaint was brought against them.
How do you prove that?
the
How do you look? There's no point just saying it out. Please show me some documents or something in support of your argument
On the
that there is some connivance and this is wrong. Otherwise, on the basis of your submission, oral submission, this court cannot decide anything.
my lord, on the basis of their complaint, verbal complaint, my lord, his license.
But they
was-
have made a
There is no
report.
complaint, my lord.
Okay, right. Heard, Mr.
Yes, yeah.
S.A. Ahmed, Learned Counsel for the petition. Also heard, Mr.
S.K. Corbett.
S.K. Bharat Kataki, Learned Counsel for the respondent number 6. Who appears for the government? Over.
1, 2, 3, and 4.
Mr. G. Bokalai, accept notice on behalf of, no, appears on behalf of response number 1, 2, 3, 4. 5, who appears on 5? Okay, no one appears for the respondent number 5. Super. Next, right. The petitioner, who is a PDS licensee, PDS will be public
Public distinction.
distribution system licensee, yeah, bracket PDS, at Gereki Nepali Gaon under Bokdung GPSS of Chabwa block of Dibrugarh district. Has prayed for setting aside the impugned order dated 14/8/2015 passed by the Deputy Commissioner Mr. Counsel, your prayer is very tricky. You have said Deputy Commissioner come Deputy Director in charge.
Yes.
Where is the Deputy in charge? In the order at page 86. Huh? Right. What do I say? Deputy Commissioner come Deputy Director, comma, IC, comma, Food, Civil Supplies and Consumer Affairs, Dibrugarh, comma, by which the petitioner's PDS license has been cancelled. Full stop. Next paragraph. The petitioner's case is that the petitioner's PDS license was initially suspended on 22/1/2015 by order dated 22/1/2015 issued by the Deputy Director IC Food, Civil Supplies and Consumer Affairs, Dibrugarh. On the allegation that, now in view of the complaint made against the petitioner that he had not lifted and distributed the PDS slash TPDS. What is TPDS?
Yes,
T-
my lord.
T means what?
Targeted, my lord, public distribution system. Targeted.
Well, then you write PDS, we have not distributed the PDS slash targeted PDS,
Yes.
commodities for the last 3 months to consumers, thereby violating clause 14 and 26. Read with the licensing terms and condition 8(1) of the Assam Public Distribution of Articles Order, 1982. The petitioner next step. Being aggrieved with the suspension of his license, PDS license, the petitioner approached this court by WPC number 1425/2050. This court disposed of WPC number 1425/2015 by order dated 17/3/2015 by holding that clause 29 by holding that the ends of justice would be served if the petitioner by holding that by agreeing with the stand taken by the state government council that there was an alternative remedy available by way of filing an appeal under clause 29 of the Assam Public Distribution of Articles Order, 1982, hereinafter referred to as the 1982, and as per referred to as APDA Order 1982. Next paragraph. In pursuance to the order dated 17/3/2015 passed in WPC 1425/2015, the petitioner submitted an appeal which was disposed of by the Deputy Commissioner and Appellate Authority, Dibrugarh, by order number DSC 2/2015/161 dated 14/8/2015. By the order dated 14/8/2015, the appeal petition of the petitioner was rejected and the PDS license of the petitioner was also cancelled. Next paragraph. The petitioner has accordingly, has by way of this writ petition, put the impugned order dated 14/8/2015 issued by the Deputy Commissioner and the Appellate Authority Dibrugarh under challenge. Next paragraph. The petitioner's counsel submit that the impugned order dated 14/8/2015 passed by the Deputy Commissioner. No, could not have been passed by the Deputy Commissioner as the suspension order dated to 22/1/2015, which was under challenge in the appeal, was also issued by the Deputy Commissioner. That's all. Anything else? That's your case. Next paragraph. The counsel for the respondents, on the other hand, submit that the suspension order dated 22/1/2015 was issued by the Deputy Director in charge, Food, Civil Supplies and Consumer Affairs, Dibrugarh, and not by the Deputy Commissioner. As such, there was no bar on the Deputy Commissioner to decide an appeal issued by to decide the appeal against the suspension order issued by an officer lower in rank than the Deputy Commissioner. That's all. They, huh? Stating what?
You are given a petition of
No, he can always file another appeal if he wants.
before the
Okay. But I have heard the learn cause for the party. The issue herein is whether the suspension order dated 22/1/2015 and the rejection of the appeal and cancellation of the petitioner's PDS license, while the impugned order dated 14/8/2015 had both been issued by the same authority, that is the Deputy Commissioner. Next paragraph. A perusal of the suspension order dated 22/1/2015 shows that the same has been issued by the Deputy Director in charge, Food, Civil Supplies and Consumer Affairs, Dibrugarh. There is nothing to show that the petitioner, that the Deputy Commissioner was the Deputy Director in charge, Food, Civil Supplies and Consumer Affairs. Was also holding the charge of Deputy Director in charge, Food, Civil Supplies and Consumer Affairs. Dibrugarh. Was he holding the charge? He was holding.
At the time, yes, at the time he was.
At the time he was holding.
Yes.
Then he could not have passed the order. Then he could not have passed the order. He said yes. Now what? What do you mean no? He said yes.
No, at the time he was.
At the time, what do you mean at the time he was not?
Deputy Director, I see, teacher, Food and Civil Supply and Consumer Affairs.
Correct. But then was the DC holding the charge that post?
This was not holding. It is not really.
How can you prove that he was holding the charge?
I asked in our video, my lord, Kampur Metro, the DC, my lord, holding the I asked him, I verified. So, my lord, that is why I am saying.
And
Now,
let them
deputy
clarify
commissioner,
why.
there are so many.
Huh?
Now, deputy commissioner, there are so many.
Maybe, Mr. Council, maybe, you see,
It appears from this kind of record, rightly he was not holding.
okay.
The
Let
next
them
time
select
was
them.
deputy commissioner was not. It appears.
But he is having two hats. He's saying that he's holding the charge.
I think.
Huh? You withdraw you take back your word. But you have already let it down. Everyone knows it. Huh? You take it back. Huh? Or what? It is recorded. Everything is now under video. It's all in video now. It's all virtual.
I took it.
Huh?
I took it.
You took it back. Whether you can take it back just like that, I don't know. Okay, anyway. Full stop. Huh? Next. The impugned order dated 14/8/2015, rejecting the appeal filed by the petitioner and cancelling his PDS license, has been issued by the Deputy Commissioner. Dibrugarh, the Deputy Commissioner Dibrugarh. There is nothing stated in the order dated 14/8/2015. But there is nothing to indicate in the order dated 14/8/2015 that the Deputy Commissioner Dibrugarh was also the Deputy Director in charge, food, civil supplies and consumer affairs. Full stop. Next para. Though the petitioner in his prior portion of the writ petition has prayed for setting aside the impugned order passed by the Deputy Commissioner, Deputy Director in charge food, civil supplies and consumer affairs, There is nothing, no, as stated earlier, there is nothing to indicate that the impugned order dated 14/8/2015 had been issued by the Deputy Commissioner, Deputy Director, IC, food, civil supplies and consumer. Next step. Clause 29 of the
29.
APDA order, 1982 provides us for page 29. A perusal of the above order clearly shows that an order made by any officer lower in rank than the Deputy Commissioner can be appealed against before the Deputy Commissioner. As the post of Deputy Director in charge food supervisor, FCS, SPFA, is lower in rank than a Deputy Commissioner. There is no infirmity with the Deputy Commissioner issuing the impugned order dated 14/8/2015. Further, next para. Clause 29(1)(c) provides that an order made by the Deputy Commissioner can be appealed against before the Commission. As the impugned order dated 14/8/2015 can be put to challenge before the commissioner, comma. This court is of the view that as the issue pertains to disputed questions of fact, the petitioner should be given the liberty to approach the commissioner. Comma, if he is advised to file an appeal against the impugned order.
Commissioner, my lord, Upper Assam,
Commissioner, Upper Assam,
Upper Assam,
Division.
Tuthar.
Jorhat. Uttar. Next para. Though there is a limitation period in filing an appeal, comma, the petitioner, the petitioner, comma, in the event the petitioner files an appeal in terms of clause 29C of the APDA order 1982, comma, the commissioner Upper Assam, appeal, Upper Assam, what?
Upper Assam, my lord, Upper Assam, Division, Tuthar.
A division, Jorhat, should consider the fact that the present writ petition had been filed on 18 September 2015, and as such, it considers the case of the petitioner, it considers the application of the petitioner for condonation of delay, comma, if any, in terms of section 14 of the Limitation Act. Huh? Five? No, not 5. 14. When you 14, 5 is different. The writ petition is accordingly dismissed, comma, with liberty being given to the petitioner to avail the alternative remedy available. Huh? Is disposed of, instead of dismissed, is disposed of with liberty being given to avail the alternative remedy available to the petitioner.
That may be, my lord, probably within 2 months.
In somewhere before disposed of, before disposed of, you just write. Yes. Before disposal, just write. In the event the petitioner files an appeal, comma, the condonation of delay application is allowed, comma. The commissioner should attempt to dispose of the appeal expeditiously and preferably within a period of 3 months from the date of receipt of the appeal.
Apply good.
Are we notice to the private? Okay.
Huh?
By giving notice to us.
Yes, okay. 3 months, no? Make it 4 months. And after giving an opportunity of hearing to the respondent number 6.
Apply good.
Who is respondent? Why is you? You have been given now the license.
New license, my lord, has been granted.
Okay, so we'll have to add
We are running the
the respondent number 6 after cancellation of the petitioner's PDS license, comma. A new license has been granted to the respondent number 6 in place of the petition.
But before cancellation, his license was granted, my lord, by cartel some basic beneficiaries from my shop.
That is a different issue. Why do you want to come in? I don't know. Cut that, don't need. No, that part. Yes, next.
Apply.
My lord, this purpose I have for the casket.
Yes. What is to be done here?
My lord, this is a case where Lordship takes the
Let us see the order.
absolute. Page 10, actually content. After page 11. May I read the order? Give it just background.
I don't think we have time.
Actually. So I will be pleased to fix it after 4th.
Okay. No time today.
Then in that case, I will make it after 2 decades. So that is taking too far. Let it be after 4th of March and finish up. I will be out of this
From
from 11th to March. Let it be on 4th March.
6th March?
Yes.
On the prayer of the parties is the matter of 6th March. Still there. No time.
Yes, what has indicated.
Okay, right. Mr. P.K. Roy appears for the petitioner. No one appears for the respondent. Are you appear?
No one.
It says Burkilal appears for the respondent. This is the matter after 2 weeks.